Audible?
Yes.
Yes, no? All right. We have another 2 minutes and then we get started. All right. Good to start?
Yes, sir.
Yes.
Brilliant. Insist you to keep your cameras on and let's get started with the session. Audible? Visible? Yes, no?
Yes, sir.
Yes, sir.
Right. Perfect.
sir.
Quite interesting to see each one of you again after a long time. Hope you guys are doing well.
Yes, sir.
And I understand you just finished one of your mock exams and now we start with the second one. Yes, and that's what is the understanding that I have. Yes, no, there in the session.
Third one.
Yes.
Third one. All right. First one. Good morning, everyone. Hope you guys are doing well. Most of you have forgotten. The time zone is still remaining good morning itself because we are going to start afresh. No thoughts, nothing else. We're just going to focus on the topic that we're going to discuss for the day. All right. So let's get started. There in the session.
Yes.
Yes.
Audible?
Yes, sir.
Yes, sir.
Yes, no, yes, all right. So let me know if the screen is visible. So what we are going to do is we're going to run through this material which we have specifically prepared only for a revision. All right. So we're going to spend 5 hours only on going through all the topics which are there as a part of your company law. Specifically, we are going to focus on Companies Act, partnership, and LLP. Of course, apart from that, we are also going to focus a little more on how to go about with answering questions in your law paper. All right, which could include some bit of Sale of Goods Act, some bit of your company of Contract Act, which we are going to touch upon as and when required. All right. So today we are going to focus spending quality time on Indian Contract Act, on your Companies Act first. All right. We're going to touch in detail each of those important phrases, words, language that you're going to write when if a particular question is asked in examination. How do you attempt MCQs? All of these in today's session. 3 hours we spend together. Ensure that you take home every single minute. Make it valuable. Make it count for your preparation. Extremely important. Let's get started. Lekha there in the session? Yes, no. Appropriate. Is the video and audio going in sync or is there a lag? All cool? Can we continue? Among? Yes. All
Yes,
right.
sir.
So let's get started, friends. 200% focus. Insist you to keep your cameras on. So what we do is first 1.5 hour, we are going to focus on Companies Act. We're going to see each and every topic that we have learned together earlier. Highlight is what is that extra focus that we are going to learn in this session is what language, what is that extract word, what is that one phrase which you're going to use if a particular question comes in the examination. Understanding? Yes. So this is how we are going to approach your Companies Act. 1.5 hour we are going to dedicate for Companies Act. Let's get started. Good to start? Yes.
Yes, sir.
Yes, sir.
Saturday afternoon, amazing movies there. All right, you guys also have had your sumptuous meal, 100% ready to sleep. Ensure that you don't do these blunders and focus on what we're going to do, why we are here. All right, let's get started, friends. So the first topic, like we have discussed, is going to be the Companies Act, 2013. All right. So the important thing that we are going to do here is we are going to see an entire chapter once. At the same time, if a particular topic is coming in examination, what is the important phrase? How do you write that is what we are going to touch upon. All right. So the first thing is Companies Act 2013. Is the first time India is seeing a Companies Act? Answer is no. We have seen Companies Act even before this. Which one? Companies Act of 1956. Understanding everyone? Yes. So Companies Act of 1956 was there. Sir, is that the first act which India has seen? No. Before that also we had another act. All right. So like this, we had multiple acts. And finally, today, as on date, that we learn is going to be the Companies Act of 2013. So what is so special about this act? This act has 470 sections, 7 schedules, and effective from or got the presidential assent on 29th August 2013. All right. May be asked in MCQ in examination. So it's good to know. When did it get the presidential assent? 29th August 2013. In the session, everyone understanding? Shrestha there, Grishma there, understanding? Yes. Next, we understood what exactly is this company, sir. All said and done. But what is this company? So first we understand the meaning of company. Company is a group of people who are coming together by so that they can give something. What? Capital. All right. They're going to give something which is going to be capital. Why? Because they are going to generate profits out of that business, and that is going to be shared amongst the members. Sir, is there a possibility of having a company without profits? Answer is no. General piece of law? Answer is no. Sir, how about Section 8 company? That is an exception. All right. Section 8 companies is just an exception. But when I'm asking you, can I have a company without profit motive itself? Answer is no. First, general piece of law. General piece of law. Then, no, sir, I don't want to make profit. Then you incorporate yourself as a Section 8. Hi, everyone. Amrita there. Devi Vaishnavi there. Yes. So this is the whole discussion on Section 2, Clause 20, the whole discussion on meaning of the word company. Sir, all said and done. But what is the definition of the word company? Interesting definition. Section 2, Clause 20 defines the word company. Company means a company which is incorporated under this act or under any previous company law. All right. So if you remember during a session, we had stressed upon what is the importance of under previous company law. If they wouldn't have used this language, Infosys is not a company. Tata is not a company. Wipro is not a company. Why? Sir, because they have not been incorporated under this act. They've been incorporated under the previous company law. So the importance of both this act as well as previous company law, both is significant here when it comes to the definition. Understanding? So tomorrow, in case if there's a question in examination, all right, you should logically think, can I just write a company means a company which is incorporated under this act? Answer is no. That is incomplete answer. Then what about Infosys? Your parents might have saved some money for your bright future. Do you remember something that I just discussed? Let's assume they have invested in Infosys. Now, what if this company, Infosys itself, is not a company? Based on your understanding, if they wouldn't have used this phrase under previous company law, Infosys is not a company. Wow. Future as bright as the darkness that we can see. I hope I'm clear, everyone. Understanding? Yes. So it becomes imperative. Yes. It becomes important for us to understand that company is defined under Section 2, Clause 20 means a company incorporated under this act. Which act, by the way? This act means which act?
2013.
2013.
Companies Act of 2013 or under any previous company law. I hope each one of us your thoughts on the definition of Section 2, Clause 20. Understood? Can we proceed? Yes, no,
Yes,
then
sir.
the session.
Yes, sir.
Audible.
Yes,
The video
sir.
and audio is going along. Yes, there's no lag. It's appropriate. Can one of you
Yes,
quickly
sir.
respond? All right, brilliant. Let's get it. Applicability of this act, sir. To whom does this act apply? This act is applicable to companies. Very obvious. If Companies Act will not apply to companies, then to whom? To you and me, individuals. To whom is it going to apply? So very obvious, sir. Companies Act is going to apply to a company. Sir, which company? Whether incorporated under this act or under any previous company law. If they wouldn't have used previous company law, that means Infosys is a company, but no father, no mother. How is it possible, sir? Because I don't have the ruling act itself. That's why I hope you understand the significance of the word under any previous company law. All right. So company which is incorporated under this act or under any previous act. This is the first point. Second, Sir, is it applicable to banking company? Yes. Sir, is it applicable to insurance company? Answer is yes. Sir, is it applicable to an electricity company or company which is engaged in generation or supply of electricity? Answer is yes. Sir, why are you specifically mentioning about this when you are saying that it should apply? 100% you're right. It should apply. Why? It's a company. But the important thing is, way back during our sessions, we had discussed, sir, they have two fathers or two mothers. There are two parents. How? One, Companies Act. The other one is their respective act. All right. Classic example, my friends from Christ College, all right, or from my friends from convent schools and colleges. If you remember, we have had the father, you have two fathers, one at home and one in the college. I hope you understand. Now, whom do we listen to or how do we listen to? The answer is given under the Companies Act itself. Companies Act says, sir, whenever there is any inconsistency between what? Between Companies Act and your respective act, I want you to follow your respective act. No confusion at all. Understood, everyone? Crystal clear? Yes. So, to whom is the Companies Act applicable? The act is applicable to all the companies which are incorporated under this act or under any previous company law. It is applicable to your insurance company, banking companies, or companies which are engaged in generation or supply of electricity. Why are we specifically mentioning here? Because these kind of companies also have their respective act. Which one? For insurance company, you have your IRDA Act. For banking companies, you have a Banking Regulation Act. For companies which are engaged in generation or supply of electricity, you have your Electricity Act. So it becomes important for us to remember that if there is any inconsistency, you follow your respective act, is what the law says. I hope I'm clear, everyone. Understood? Understood? Yes. Apart from this, sir, is it applicable to anyone else? Any other company which is governed by any special act, this act is going to apply to them as well. Next, such body corporate which are incorporated by any act for the time being and as the central government may notify. If central government is specifically telling it is going to apply to you, then it is going to apply to you. As simple as that. Understood? Yes. Crystal clear with the concept? Yes. No.
Yes.
Then in the session, respond.
Yes,
Respond.
sir.
Expect a question here. Expect a question here. Expect a question here. Important language that you will have to focus is, it is applicable to banking companies, electricity companies, companies which are engaged in generation or supply of electricity. But important thing is, however, if there is any inconsistency in the provisions of law between Companies Act and the respective act, which act? If it is insurance company, Insurance Act, and IRDA. All right. If it is banking company, Banking Regulation Act. If it is a company which is engaged in generation or supply of electricity, it is your Electricity Act. I hope I'm clear, everyone. Understood?
Yes.
Understood. Vijayta there? Roshal there? Yes. Next,
Yes, sir.
let's proceed.
Yes,
I
sir.
need response, friends. I need response. So keep responding. Next, characteristics of company. Sir, what are the features of company? There is a possibility that they can ask a question for 1 mark, 2 marks from here as well. Very simple, chiller topic. First point. All right. Company is a corporate personality or a separate legal entity. It is just like a natural person. It is not a natural person. Huh? Mind the language. Don't write in examination, company is a natural person. Why? Did it come, marry you? You married the company. How, sir? What language are you even talking? Hope you're clear, everyone. Yes. Then what is a company? It is a person. But what kind of person? Artificial person. I hope I'm clear, everyone. Understanding? Yes. Is it a company? Yes. Yes, it is a company which is a person. But is it a natural person? No, it is like natural person who can enter into contracts, who can buy property, who can sell property. It can do anything and everything that you and I would have ordinarily done in a business transaction. Case law, important case law, Solomon versus Solomon Company Limited. If you remember, we have discussed this case law. Important to remember this case law from exam perspective. All right. Next, company is an natural person. Something that I already told you. Is it a person? Yes. Is it a natural person like you and me? Answer is no, because you and me are natural persons. So then what is company? It's an artificial person. Understood? Yes. Pratiksha there in the session. Next point. Company. Is it a citizen? Important point. We've discussed this earlier as well. All right. Is company a citizen? Answer is no. Company is not a citizen. So then when I say Infosys as an Indian company, what do we mean by the word Indian? Sir, you're not referring to the citizenship, you're referring to the nationality. You're not referring to the citizenship, you're referring to the nationality. All right. Sir, how can you say authoritatively that it is not a citizenship? Sir, that's because your section 2, all right, section 2, clause F of the Citizenship Act itself says it excludes a company or association or a body individual from the citizenship. Understood, everyone? Diksha there, Shant there, Sai Tejaswini? Yes. Next one. company has nationality and residence, something that we have already mentioned. All right. Does company have a nationality? Yes. Infosys, Indian company. All right. Let's assume Wipro, Indian company. So what are we trying to say? Sir, it is not the citizenship, but it is a company which is based out of India. So we are calling it as an Indian company because of the nationality. Sir, does it have its own office? Answer is yes. It's the registered office. And that is nothing but the residence that we are talking about. Understood, everyone? Crystal clear with the concept? Everyone? Yes. Next.
Sir.
Liability. Do you remember the example that we had taken for liability? Can anyone help me out? What was the example?
Chota
Bheem
Bheem.
Private Limited. Brilliant, brilliant. Guys, this is the beauty. This is the beauty. All right. Of attending sessions, being there, because you will be able to recall something at least. So if you remember, when it comes to your Chota Bheem Private Limited, you were a shareholder of Chota Bheem Private Limited. You had borrowed, you purchased a 10 rupee share. Now, out of this 10 rupees, 6 rupees has been paid. Tomorrow, let's assume the company has to pay 1 crore. How much is your liability?
Only 4 rupees.
4 rupees.
Only 4 rupees.
Is there any second thought? Answer is no. No second thought at all. Why? Because of the concept of limited liability. My liability, the privilege of limited liability for the business debt is one of the principal advantages of doing business under the corporate form of organization. What do we say? What are we trying to say here? Sir, my liability is limited to the amount that I'm not paid on the shares. All right. The share price might be of 10 rupees, but out of this, I might have paid 6 rupees. My liability will be only to the extent of 4 rupees. I hope I'm clear, everyone. Understanding? Guys,
Yes.
you will have to
Yes,
appreciate
sir.
that you're able to recall. I'm not sure if you're able to remember everything. It's okay. If you're not able to remember everything, that's absolutely fine. But at least make an attempt to recall as much as possible. That's why I'm giving you the cross-referencing of the examples as well. Understanding? Yes. Next, perpetual succession. All right. Classic example. Anyone? Dhirubhai. Reliance.
Men may come, men may
Reliance.
go.
Dhirubhai Ambani. All right. Men may come, men may go, but company will go on forever. This is the phrase that we had learned. Yes. What are we
Yes.
trying to say? Just because Mr. Dhirubhai Ambani is in there, Reliance closed? Reliance closed their business?
No, sir.
Answer is no. It Ambani. Why? Because men may come, men may go. Company will go on forever. I hope I'm clear, everyone. Insist you to keep your cameras on. Insist you to keep your cameras on. Next point. All right. Separate property. All right. So Amog has decided to purchase 10 shares of which company? Let's assume ITC. All right. Amog was there. He has purchased the shares of ITC. Now listen to me very carefully. Amog says, I am the owner of the company. So whatever property of ITC is, it belongs to Amog. Wow.
No, sir.
No, sir.
It doesn't make sense. If that is the case, then what will Rakshita do? She'll buy 1 share of all the companies in India and say their property is my property, right? Because I'm the owner, right? Wow. Then everyone is richer than Dhirubhai Ambani, richer than Mukesh Ambani, richer than Bill Gates. Why? Because you have the entire property of the country itself in your hand. Is it even making sense? No, nonsense. Why? Because of the concept of separate property. What is this concept of separate property, sir? A company being a legal person and entirely distinct from its member is capable of owning, enjoying, and disposing the property in its own name. Everything is done by itself in its own name, and that's the whole discussion on separate property. I hope I'm clear, everyone. Understood? Crystal clear? Yes.
Yes.
Last year there in the session. Last year there in the session. Yes.
Yes, sir.
Let's go ahead. Transferability of shares. Last year is annoyed. Let's assume she has 10 shares of Mehul Limited. All right. Now she says this guy is going to yell at the top of his voice unnecessarily. He is disturbing me. Let's transfer his shares. Can she do it? Yes, 100% she can do it. No one on earth can stop her from transferring shares. This is the beauty of companies. All right. Where you can transfer the shares. Sir, in the event of death, what is the language we use? We don't use the word transfer. We use the language transmission of shares. All right. So transfer comes where you voluntarily want to transfer the shares. In the event of death, where a person, the deceased person shares are going to the legal representative, the language used is transmission of shares. I hope I'm clear, everyone. Understood? Yes. Next point. Capacity to sue and be sued. Example. Quick example.
Maggie.
Example. Maggie, Nestle. All right. This is the whole discussion that we had on Nestle. If you remember, mute yourself. The whole discussion that we had on Nestle. So let's assume in case if you want to file a case against the company, can you do so? 100% yes. If the company wants to file a case against you, can it do so? 100%
Yes,
yes.
sir.
Why? Because of the characteristic or feature called capacity to sue and be sued. All right. Next one. Contractual rights. Can a company enter into contract? 100%
Yes, sir.
yes. A company can enter into contract. Why? Because it has the rights to enter into contract and it can do anything and everything which a person ordinarily would have done. Understood? Vijita there in the session. Understanding? Limitation of
Yes, sir.
action. All right. So what is the meaning of this? Just because you're a company doesn't mean that you can do anything and everything under the sky. Law says, wait, control. All right. If I give you the permission to do anything and everything, you'll start smuggling gold. You'll start doing all the possible illegal business. Wait, control. You cannot go beyond the memorandum of association. And this is called limitation of action. No, sir, I want to go beyond the memorandum of association. No problem. There's something called as ultra vires. Doctrine of ultra vires, which will come into picture, which we are going to discuss later. Understanding everyone? Yes. So this is about your
Yes, sir.
Yes, sir.
limitation of action. All right. A company cannot go beyond the power stated in its MOA. Next, separate management. All right. Diksha says, I am having 10 shares of Wipro. Diksha is saying she has 10 shares of Wipro. She says, I am the owner. I will decide what the company is to do. Wow. In that case, Diksha, why don't you take 10 shares of all the companies in the country and decide how they have to run their business? Is it even making sense? Law says,
No,
wait,
sir.
control. That is not possible because of the principle of separate management. Now, what is the separate management? Management is different from ownership. Just because you are the owner does not mean you will decide how the business has to be run. So then who's going to decide? It is going to be the management who's going to decide how the business is to be run. Understood, everyone? Yes. Next point. Voluntary association of profit. At the end of the day, why are you starting the company? For the purpose of profit. For the purpose of profit. No, sir, I don't want to earn profit. You call yourself a Section 8 company then. You cannot be an ordinary company because all the ordinary companies have to be incorporated for the purpose of earning profits. No, sir, I don't want to earn profits. It's okay. Call yourself as a Section 8 company then. You will not have any profit motive in that case. All right. A Section 8 company is a company which does not have an objective of making profits. Am I making sense, everyone? Yes. Understanding?
Yes,
Yes.
sir.
Yes, sir.
Next, termination of existence. Sir, when will a company come to an end? If I have to say a company has come to an end, when will it come to an end? It will come to an end when it is being wound up. All right. The only way where a company can stop existing, the only way where a company will come to a closure is when it is wound up. All right. When it is wound up. So what is it? The creation is by law and the termination has to also be by law itself under the procedure of winding up. Very obvious. Look at the language. Very interesting. One who created is the only one who can kill. All right. It's the same language. The creation is by law. So the winding up or termination of the company can also be only by law, and that is by the procedure of winding up. I hope I'm clear, everyone. And the last point is common seal. All right, this is one favorite question in examination which they often ask. Why? Because there is an amendment. So what is the discussion here, sir? Common seal is the seal. Again, the same example where you have the company's logo printed, and that is a round seal which is put on of the company. Are you able to understand what we are talking about? The common seal? Yes.
Yes, sir.
Sir, is it mandatory that a company must have a common seal? Law says, I have better things to do. All right. At one point of time, I told, yes, a company must have common seal. Nowadays, no one bothers seeing a seal. Everything is on electronic media. Everything is happening over emails and everything is digitized. Why do you want? I will sit and check the seals. If you want, you keep. If you don't want, don't keep. Sir, but how did this happen? This happened through the Companies Amendment Act of 2015, where they made common seal optional. All right. That's sir, I have better things to do. I really can't sit and decide whether you must have a common seal, how it has to be maintained, who has to maintain. All that I can't do. So therefore, I made it optional. If you want, you keep. If you don't want, don't keep. Understood? Understood, everyone?
Yes, sir.
Till now, whatever
Yes,
we have discussed, expect a question from there. All right. Till now, whatever we have discussed, there could be a possibility of question coming in examination from there. Understanding? Yes. So be prepared. Be prepared. Ensure that you're giving to your 200% while we are discussing. Important topics are being touched upon. Understood? Can we proceed? Yes. Next.
Yes,
Doctrine of
sir.
lifting of corporate veil. Can anyone help me out? What is the example? Which example? Brilliant. All right. If you can just try to picturize the example that we are talking about. Tom Private Limited. All right. Tom wanted to smuggle goods. He knew that in case if he smuggles good, the cops are going to catch him. So what he did, he started a company. Which company? Tom Private Limited. Why? Sir, because you only taught, no, corporate, separate personal legal entity, separate existence. The company and the person who started the company are not in the same. You only get the gyan, no? So therefore, I will create a company. Which company? Tom Private Limited. They start smuggling goods. All right. They have started smuggling goods. Now, what is going to happen? Tomorrow, if the cops catch Tom, what is he going to say? Who smuggled the goods? Tom Private Limited. Go catch Tom Private Limited if you can. Law says you're smart. You're smart. Lawmakers are smarter. They came up with the concept of doctrine of lifting of corporate veil or piercing the corporate. What are they saying? I will ignore the existence of the company, lift the curtain and check who's that person behind. Lift this entire veil and check who's that person behind, and that person will be held responsible, and that person will be liable for all the debts and obligations of the company. Understanding, everyone? Yes. Classic example. The moment I talk about
Yes, sir.
Kingfisher, there is some name which is coming. I don't want who it is. There's some name which is coming in your mind. I'm not talking about the substance. I'm talking about the person. This is actually scary, because when I end up giving this example of Kingfisher, people already get high. Why? I don't know. The whole point is, what I'm trying to say is, I'm not talking about the substance, but the person. What are you guys doing? The moment I talk about Kingfisher, you are telling something is wrong, and you're coming up with some name there. Why are you coming up with the name? Because you're applying the corporate of or doctrine of lifting the corporate veil. Understood? Able to understand what we are talking about? Yes. So what language
sir.
do we use in examination? You can't write Kingfisher and come in examination. I hope you realize. All right. So what language do we use in examination is extremely important. Look at the language. So what I've done is I bolded it to ensure that you guys get a fair idea of the topic. All right. So what is this corporate veil? The separate personality of a company is like a power. All right. It is some privilege that I've given to you. What is this privilege? It's a statutory privilege which I've given it to you. You please use it only for legal businesses, for legitimate businesses. In case if you go ahead and carry out any fraudulent or dishonest use of it, and if you're taking shelter under this corporate personality, the court will break through the corporate shell. Are you able to understand how strong this language is? All right. They will break the corporate shell. Check who's the person behind it. All right. They will break the corporate shell and apply the principle or doctrine of what is called lifting off or piercing the corporate veil. The court will look behind the corporate entity and take action as though no entity separate from the member existence, and makes the member or the controlling person liable for all the debts and obligations of the company. I hope I'm clear, everyone. Understood? Understood? Yes, crystal clear?
Yes, sir.
There's a high possibility of this coming in examination. They will give some cranky case study, all right, and they'll ask you to see who's the person responsible. You have to just come down to the basic point. Why did I give you the example of Tom Private Limited? Because he is using some company for the illegal business. All right. Second, why did I give you the example of, pay attention, why did I give you the example of Kingfisher? Because you know that he was using it for some fraudulent activity. So just keep this in mind and apply the principle as the case may be. Understood? Now, corporate veil can be lifted in 5 scenarios. Let's quickly see what are those 5 scenarios. Is the screen visible? Yes? No?
Yes, sir.
So
Yes.
corporate veil can be lifted in 5 scenarios. The first one is where you're trading with enemy. Manthan there in the session? Yes. So the
Yes,
first one is where you are trading with the enemy. I will not accept. Enemy, do you remember the example? Let's assume you've gone back during Kargil war and we are discussing about a scenario in 1999. Kargil war is going on and you've entered into a transaction. Law says don't enter, but you've done something. Law will just lift the corporate veil and check who's the person behind it. Do you remember the example? Same example. I'm not even changing any of my examples. All right. Second, sir, where it is a scenario of evasion of taxes, where you're trying to evade taxes, avoiding taxes. Do you remember the example? One person getting loan or dividend from 5 different companies. He said, why to pay taxes? Rather start 5 different companies, transfer his shares in those companies and let the dividend come to these companies itself. Then what will I do? I will send it in the form of loan to the member again. What am I doing? I'm just avoiding taxes. Law says you're smart. Lawmakers are smarter. You're trying to evade the taxes. I will lift the corporate veil and check who's the person behind it. Understanding, everyone? Yes, last year there in the session. Next one. All right. That's the name, right? That's the name, right? All right. Perfect. Next one. where the company acts as an agent of any of the subsidiaries, all right, where it was formed as their subsidiaries to act as their agent. In that scenario, I'm going to lift the corporate veil. Fourth scenario, where I'm trying to avoid legal obligation. Legal obligation, do you remember they're supposed to give lunch, food, all right? If you have more than 20 employees, you have to give food. But let's assume it was your company. You said, why will I pay for their food? Instead of 20, if it is more than 20 employees, I have to give, right? Let's assume there are 22 employees. What did you do? You
Form another company.
transferred 7
Form
employees to another company. You formed another company. Is there losses? You're smart. Wait, what are you trying to do? You're trying to avoid legal obligations. I will not let you do this. And the last one, where you are carrying out only for some illegal purposes, improper purposes, then that scenario also, this becomes the fifth bucket where I'm going to lift the corporate veil and ask you to pay the taxes, or I'm going to ignore the existence of the company. Understood, everyone? Understood, everyone? Crystal
Yes.
clear with the concept?
Yes, sir.
Now, let's go ahead with the next point. All right, let's get started. Companies can be classified into incorporated companies
Incorporated company.
and incorporated companies.
Yes, sir.
If you were there during a regular classes, you'll be able to understand what I'm talking. Most of you thinking this guy has gone nuts, but please not understand. What am I trying to talk here is companies can be classified into incorporated companies and incorporated companies itself. Sir, what is this unincorporated? There is some discussion. Let's park it aside right now. Let's not get into it. For the purpose of company, you have to be incorporated. Sir, how can you say this authoritatively?
Companies Act only says, sir.
Definition of the word company. Company means a company which is incorporated under this act or under any previous company law. When I'm saying in the definition of a company itself that it has to be incorporated, how can you have unincorporated companies? All right. But is there a logic to it? 100% there is a logic. It is just that it is not relevant from your syllabus perspective right now. I hope I'm clear, everyone. Understood? Yes.
Yes.
Now,
Yes, sir.
incorporated companies can be classified into three buckets. All right. There are three types of incorporated companies. First one, registered company. The word itself says it is registered, which is registered under the Companies Act. It is called registered companies. Simple as that. Understanding? The second one is called statutory companies. Those which are brought into existence by an act of parliament. Example, LIC.
LIC.
All right. Where it is being brought into existence by an act of parliament, it is called statutory company. Third one is called chartered companies. Example, East India Company, where it is brought into existence by a charter of the monarch. Who's the monarch? The kings or the queens. If they are bringing into existence any company, they are called chartered company. Classic example, your entire discussion on East India Company, if you remember. All right, 6th, 7th, 8th, history by mistake, if you remember. Yes, sir, we don't remember what we ate in the morning itself. What you're asking 6th, 7th, 8th, my mistake. I'm sorry, I shouldn't be asking. I agree. All right, now, registered companies can be classified based on guarantee, or it could be unlimited companies. All right. Now, if it is based on shares, that means it is based on share capital. It can be a public company or private company. What is the definition of each of these? We are going to see. Don't worry. All right. So these are companies which have shares, which has a share capital, and based on that, we are classifying them. That is called as a company which is classified based on shares. Second, companies which are based on or limited by guarantee. What is this? Classic example, Mysore Silk Emporium, Karnataka Silk Emporium. What is this? Where the government itself, at the incorporation itself, is giving a guarantee for what? Tomorrow anything happens, I will give you 2 crores. Let's assume company has to pay 20 crores. How much is my liability? Limited to 2 crores. But when am I deciding this? I'm deciding this at the beginning itself. At the inception itself, it is being decided. Tomorrow when the company is being wound up, I give the guarantee of repaying 2 crores. This is called company limited by guarantee. What is unlimited company? Something like yours. All right. No limit at all. Where there is no limit to the liability at all, you might have to sell your personal property, sell your kidney, sell your house, sell yourself, bring in the money. That is called unlimited company. Understanding, everyone? Yes. So we're going to discuss each of these in detail. Let me know if the screen is visible. All right.
Yes,
so,
sir, it is visible.
Unlimited company. Let's quickly understand what exactly is unlimited company. So unlimited company is defined as no limit on the liability of the members. But when will the liability cease? When will it come to an end? When you're not a member. If you're a member, liability will be unlimited. Third point, sir, when will it start? The liability will become unlimited only when the company is being wound up. When the company is in existence, will the liability be limited? Yes, at
Yes.
that time it will be limited. But tomorrow, when I'm winding up the company, at that point of time, my liability is going to become unlimited. Understanding, everyone? Is it making sense? I repeat, pay attention. When the company is operating, when it is operational, what is the liability? It is going to be limited.
Liability.
But tomorrow, let's assume I've decided I want to close the company itself. Now,
Unlimited.
sell your house, sell your kidney, sell yourself, bring in the money. Bring in the money. I hope I'm clear, everyone. Understanding? Yes. So this is the whole discussion on your unlimited company. Now, companies can be classified based on the number of members as well. The first one is public company. The second one is private company. And the third one is OPC or 1% company. 200% focus. Extremely important discussion that we are having. Sleepy?
No, sir.
No, sir.
No.
Is that delayed response because you just woke up, or how is it?
No, sir.
No,
sir.
Are you sure?
Yes,
Yes,
sir.
sir.
Yes, sir. Yes, sir.
Right. Now,
100%.
listen to me very carefully. Listen to me very carefully. Let's get started first with the OPC. Now, what is this OPC, sir? As the name itself suggests, 1% company. The company is going to have one person. Minimum 1%. Don't you dare
Only
use
1%.
this language.
1% only.
Only
There's
1%.
only 1%. Can I use the language minimum 1%? Sir, what is minimum? Then can you have 2%? In a 1% company, I have 3%. Wow. How is it a 1% company then? I'm telling you, you're laughing now. All right. Everyone is laughing now. But I bet on the fact that there will still be blunders when you're writing the examination. I want you to be very cautious of using the language. I cannot use the language minimum 1%. Only one person who's going to be the member. All right. This is about your OPC. In detail, we are going to discuss. Second is your private company. What is a private company? Private company means a company which is having three things: R, L, P. Restriction, limitation, prohibition. What is the restriction? On the transferability of shares. What is the limitation? On the number of members. How many members? 200. Prohibition, don't you dare think about going to public for subscribing to your securities. You cannot invite public to subscribe to your securities. Understanding, everyone? Yes. Next,
sir.
public company, very simple. Best definition under the act. What is
Not
a
a
public company?
private.
A company which is not a private company. If you just write this much, you will not get marks. If you just write this much, you will not get marks. What is important is the proviso. What do the proviso says? We are going to discuss each of these now in detail. Can we get started, friends? Yes, there in the session.
Yes, sir.
Shanuja there. Shanuja there. Understanding, Nivedita. I insist you to keep your cameras on. Ashwini, Grishma, there in the session. Gaurav, Mukh. All right, brilliant. Let's get started now. 1% company. As the word itself defines, section 2 clause 62. I want each one of you to remember the section numbers. Section 2 clause 62. 1% company means a company which is having only 1% as member. Now, sir, what is it, sir? Is it a public company or private company? Sir, it will be considered as a private company itself unless otherwise provided. So whatever rules and regulations are applicable to a private company applies to 1% company also, unless the act itself provides. If the act itself is saying it is not applicable to any 1% company, don't apply it to 1% company. Example, cash flow statement. All right. If you remember, you have something called cash flow statement, which is applicable to private companies as well. But the act itself says, don't make cash flow statement for 1% company. Crystal clear, everyone? Understood the concept? Can we proceed? Yes. Now, next one. This 1% company must have to their memorandum one subscriber. All right. Sir, minimum one subscriber. Don't you dare use this language again. What is the meaning of the word subscriber? The first shareholder. First member of the company. All right. Can I have minimum first person in case of OPC? What is that minimum one first? You will eventually end up with the point that there is minimum 1%. You cannot have minimum. It is only 1% in case of your whole discussion on
OPC.
1% company. Sir, tomorrow anything happens to that 1%, who will take care of the company? Therefore, I know that tomorrow anything can happen to him. So therefore, today itself, when you're forming the company, give me the details of your nominee. All right. So I will give the details of the nominee today itself. So the law says memorandum shall state the name of the person who in the event of death of the subscriber shall become the member of the company. Language. All right. In the event of death of the subscriber, who's subscriber? The first shareholder. This nominee will become the shareholder or member of the company. Understanding everyone? Yes.
Yes, sir.
Apart from this, sir, in your name, I have to ensure that the word is mentioned that you are a OPC private company, minimum 2 members. OPC, only 1 member. All right. However, maximum that you can have in a private company is 200. In OPC, maximum
Only one person.
there's no question of minimum maximum. Don't you think about using the language minimum and maximum when it comes to OPC. I hope I'm clear, everyone. All right. So then how about directors? Minimum 2
1.
directors in case of private company. Listen to me very carefully now. Private companies, minimum 2 directors. OPC, minimum 1 director.
Yes, sir.
So just now you told only 1, no, sir. Only 1 is the member. Director, I can have more than 1. Who is the director? He's just an employee of the company. I want 1 extra person who's a techie. Let's assume I've started a company into finances. I don't understand technology. So in that case, if I'm hiring some director, he's just an employee. Can I have employees in 1-person company? Yes.
Yes, sir.
Just because you are an employee, can you call yourself as the member of the company, shareholder
No,
of the
sir.
company? Wow.
No, sir.
Wow. Then all of us, let's become employees in all the companies so that you become the members of those companies and you're the owners of the company. Wow. Nonsense. I hope you realize.
Yes.
Understanding everyone? Yes. Can
Yes,
we
sir.
proceed?
Sir.
Next
Yes,
one.
sir.
Next one. So can I, who can start this OPC? All right. First point, pay attention to the details. 2 things that we're discussing. 1, we're talking about who can be that member. Who is that member in OPC? Second, who is that nominee in case of OPC? Pay attention. 3 important points that we are touching upon. First, he should be a natural person, Indian citizen. Earlier, they said he has to be a resident of India also. All right. 3 conditions. Natural person, Indian citizen, resident of India. But thanks to COVID, you can sit in any part of the country now, like you are sitting at your respective homes, but still we are all 100 of us are still connected. Law realized that this is not possible, that I should bring something on residential. So they said, whether you're resident or not. All right. So now the 3 conditions are natural person, Indian citizen, whether you are resident or not, I don't care. But tomorrow Pooja is going to ask me, sir, who is this resident? What is this resident that you're talking about? So today itself, I'm telling, resident means a person who's staying in India for a period of not less than 120 days. When? In the immediately preceding financial year. In the immediately preceding financial year. 120 days in the immediately preceding financial year. I repeat, 120 days preceding financial year. Why am I repeating is because there was an amendment. Earlier they were using the language calendar year. Understanding everyone? Understanding everyone? Crystal clear?
Yes, sir.
Earlier the lawmakers were using the language of calendar year. Now it is crystal clear. Please use the language financial year. I hope I'm clear, everyone. Yeah, Lekha, there in the session. Understanding? Yes. Can we proceed? Next point. Can I have more than 1 member in OPC? Don't even think. You cannot have more than 1 member in OPC. Can I have more than 1 nominee in the OPC? Sir, what will you do? Tomorrow, if there's a fight, you will come and resolve. You have already, let's assume Mr. X has 2 nominees in his OPC. Mr. X dies. Now, who's going to be the member? In 1-person company, there's a possibility of 2 members coming. Then it is not 1-person company anymore.
It becomes private.
I hope you're understanding. So therefore, can I have more than 1 nominee in case of OPC? Answer is no. You can't have more than 1 nominee. Can I have the same person as a member in 1 OPC and nominee in another? Law says don't even think.
No,
Why?
sir.
Because wherever you are a nominee, in that OPC, if the member expires, you will become a member there. Eventually, you'll end up becoming a member in 2 OPCs. I don't want you to handle so much. You handle 1 company, that also is more than enough. All right. Last, can a minor become a member or a nominee? Law says don't even think.
No,
You're a
sir.
minor, you cannot enter into contracts. I don't want you to even think about it. I hope I'm clear, everyone. Understood? Understood?
Yes, sir.
Yes, sir.
Can an OPC be converted into public company or private company? Yes, 100% it can be converted into a public company, private company. Can it be converted into a Section 8 company? Don't even come close to the concept of Section 8. First of all, you're 1 person. Upon that, you want to run a Section 8 company. What is a Section 8 company? A company which is for the object of serving people at large. Sir, you serve yourself first. You serve yourself first. All right. Then you think about larger organization. We don't want Section 8 companies to be touched by your OPCs. So tomorrow in examination, there could be a question. Listen to me very carefully. Can a Section 8 company be started as OPC? No.
No, sir.
No, sir.
Can an OPC be converted into a Section 8 company?
No, sir.
OPC and Section 8 company, two enemies altogether. Easy for you to remember. They are enemies and they cannot go hand in hand. I hope I'm clear, everyone. All right. Mutually exclusive is the language that you can use for the purpose of your discussion. Understood? Yes, Rakshita there. Understanding?
Yes,
Pooja, Sai,
Yes,
Tejaswini, Manthan?
Yes, sir.
Let's proceed. Let's proceed now. Definition of private company under Section 2 Clause 68, 200% focus. Private company means a company which by its articles of association is having three things. What three things, sir? There's a restriction, there's a limitation, and there's a prohibition. I hope, guys, I'm sure you might not be able to remember everything, but at least somewhere, somehow you're able to recollect something. That should be good enough. That should be good enough. All right. I'm sure you will not be able to remember everything. That's okay. But try recollecting things at least. Anu, you are there in the session? Yes, Amrita. So three things are restriction on what? Transferability of shares. That means you can, but there are a few terms and conditions. Limitation on the number of members. How many? Not more than 200. Prohibition. Don't even think. Forget about possibility. Don't even think about going ahead and inviting public to subscribe to your securities. Three important characteristics, three important features to be satisfied. Only then you will be called as a Section 8 company. I hope I'm clear, everyone. Sir, for the purpose of this 200 limit that you're talking about, how about joint holders?
Consider them as one.
Those employees, ex or present employees, whoever they are, if they become the shareholder by virtue of employment, all right, if they become the member because they were in employment, don't include them for the purpose of calculating your limit on 200. All right. So what language do we use? Employees of the company who became the members by virtue of employment. Language. I hope everyone is focusing on the language. All right. The employees of company who became members only by virtue of their employment. They are members because they are employees. If they weren't employees, then they wouldn't have become members as well. All right. If I am employee, then I become a member. Should I be included in 200? Losses don't.
No, sir.
Don't include them for the 200 calculation. Understood? Yes. Next point. The employees of company who became members by virtue of their employment shall not be counted, even though as on date, today, you are not my employee anymore. You were my employee earlier. Today, you are not my employee. But you became the member because you were in employment sometime in life. That is nothing but ex-employees that I'm talking about. Can ex-employees be calculated, considered in 200? Don't include them if they have become members by virtue of employment. Because you have given your sweat, time, money, and efforts to the company, I'm appreciating your efforts. I'm acknowledging your efforts by giving you shares, which is through an ESOP. What is an ESOP? Employee stock option plan. Understanding, everyone? Hi, Funda, too much? Able to understand?
Yes, sir. Yes, sir.
Understanding?
Sir,
Sleepy?
Yes, sir.
All right, sleepy. Fair enough. Let's go ahead then. All right. Next point. Private company characteristics, something that we have looked into. Important thing is, again, public company, Section 2 Clause 71. Important. Public company means a company which is not a private company. Will this be asked in examination? Don't get excited. No, they will not ask this simple point. What will they ask? The proviso. What is the proviso? The proviso says, if you are a subsidiary of a public company, that means your parent is a public company. Pay attention on screen. If your parent is a public company, you are a subsidiary, you're a child, and the child is a private company. Law says, I don't care. Even though as per your articles of association, you are a private company, but I will assume, I will consider you to be a public company, and I call such companies deemed public company. Classic way to remember this is, father is Hindu or mother is Hindu. What is your religion? By birth. What is your religion?
Hindu.
Hindu.
Father or mother is Muslim. What is your religion? By birth.
Muslim.
Same way. If your parent is a public company, you are a subsidiary of that company, will you be considered as a public company? Answer is yes. No, sir, by articles of association, I'm a private company. I don't care. I don't care. For the purpose of this act, I will deem you to be a public company itself, and such companies are called deemed public companies. Sir, can we have a flip side? Parent is private company, subsidiary is a public company.
No,
Will you
sir.
deem me to be a private company? Wow, deemed private company. Don't create something which does not exist. You are neither God, neither I am God. So let's not create something. All right. In private company, don't bring all this in examination. There's only deemed public company. I hope I'm clear, everyone. Understood? Understood? Crystal clear with the concept? Yes.
Yes, sir.
Expect a question on whatever we have discussed till now. All right. I'll probably entertain all the questions only at the fag end, because this session is more of a revision. I'll take all questions later on. All right. Next point. Small company. Expect a question here because there's an amendment. Small company. Expect a question here. There's an amendment. Is this all right? Shreya's there. Understanding? Yes. Is the screen visible?
Yes, sir.
Yes.
Yes, sir.
What is a small company? Small company has been defined under section 2 clause 85. What is a small company? Small company means a company which is satisfying two conditions. What is the condition? Paid up capital should not exceed some amount. Turnover should not exceed some amount. How much is the amount? Paid up capital 4 crores. Turnover 40 crores. There's an amendment here. There's an amendment here. There's an amendment here. Earlier, it was some other figure altogether. It was 2 crores and 20 crores. Now they've recently updated. All right. 4 crores, 40 crores. They doubled it. All right. So, sir, any of these conditions or both the conditions? Any of these conditions have to be satisfied or both the conditions?
No, sir.
Pratiksha?
Both conditions.
Both, sir. Cumulative.
Don't even think about it. Both the conditions have to be satisfied by the language used is and. The language used is and. I hope you remember the blunder that lawmakers had done initially. All right, we had discussed because they had used or. Infosys said, I am also a small company. Okay, Infosys is a small company. Then who's big? I hope I'm making sense, everyone. All right. No, right now I'm not making sense. Lawmakers also understood their mistake. That's why they changed from or to and. I hope I'm clear, everyone. Both the conditions have to be satisfied. Paid up capital, turnover. Crystal clear with the concept? Yes. Amendment.
Yes.
4 crores, 40 crores. 4 crores, 40 crores. All right. Let's proceed now. Conditions or other companies which cannot become a small company. Again, a question asked in examination, 200% focus. All right. Small companies not include or the following companies cannot become a small company if it is a public company. Sir, you are a public company. How can you call yourself small? Why? Because you are a public company. You can go to the public and beg, borrow, steal. I don't want you to call yourself a small company. Understood the logic, everyone? Second, sir, I am a company which is a holding company. That means you have your children to support you. How can you call yourself small? Because you have someone to support. I don't want you to call yourself small company. Sir, I'm a subsidiary company. That means you have your parent to support you. Don't call yourself small company. Sir, I'm a section company. Sir, already you're doing something large. Don't call yourself small. You're doing something big only. So don't call yourself small. You're a section 8 company. Understanding? And the last one is any company which is governed by any special act. Example, LIC. All right. Any company which is coming into picture because of a special act of the government, then in that case of the legislature, in that case, these companies cannot be called small company. Understood, everyone? Expect a question here. Expect a question here. Expect a question here. Understood?
Yes, sir.
Let's proceed. Let's proceed. Holding and subsidiary under section 2 clause 46 and section 2 clause 87. Pay attention. Section 2 clause 46 defines subsidiary. Section 2 clause 87 defines holding. Understood, everyone? Yes. Section 2 clause 46 defines subsidiary. Section 2 clause 87 defines holding company. Let's continue. Yes. So, am I audible?
Sir, holding is section 2.
Holding is
Just wanted to check how many of you are just nodding for the sake of it. You will have to pay attention while I'm taking sessions. All right. You will have to pay 200% focus. Think logically. Time and again, I've told you, alphabetically, they've arranged the section numbers. My school teacher somewhere when I was in kindergarten, she clearly told me S comes after H. I hope so. Your school teacher also would have taught the same thing. holding company comes under section 2 clause 46. Subsidiary is coming under section 2 clause 87. Pratiksha is thinking, no, sir, my teacher taught something else. Listen to me very carefully. I'm talking about alphabetically being arranged. Understanding everyone? Yes. So what is the subsidiary, sir? Section 2 clause 87 says, sir, if you are a company in which another holding company is controlling or is having the following 2 points. What 2 points, sir? First one, where they control the composition of board of directors. That means they decide who all are going to be the board of directors in your company. That means you are their children. Why? Because who runs the business at the end of the day? The board of directors. If I decide who all are going to be the board of directors, don't you think they will do work as per my instructions itself? Don't you think they will work as per my instructions itself? That means I am indirectly holding and controlling your business. I will call you the subsidiary and I will become the holding. So this is the first one where another company is controlling the composition of board of directors. All right, controlling the composition of board of directors, it becomes the first condition. Second, where this is the first way, or the second way is where another holding company, the other company or the holding company is controlling more than what? More than one half. What is one half? One half is 50%. More than one half of the total voting power is held by that other company. Then it will be called. Then it will be called.
1%.
More than one half only.
I don't think there's any confusion here. It is more than one half. All right. One half is nothing but 50%. No confusion at all. So more than one half, if another company is controlling, what more than one half? Total voting power. Sir, who should control? Either on its own or together with one or more of its subsidiary. If it is holding, then I will call such companies as holding and subsidiary companies. Understood? We've solved a couple of examples in our sessions. What is on its own and together with some or more of its companies together. Understanding everyone? Yes, they're in the session.
Yes,
Understood?
Yes, sir.
Yes.
Yes,
For those of you who are not
sir.
able to recollect, for those of you who are not able to recollect, let me quickly revise this for you. 200% focus. Let me know if the screen is visible. Is the screen visible?
Yes, sir.
Yes, sir.
All right. So pay attention. Scenario 1, case 1. All right. Case 1, H is holding 51% in S. How many holding subsidiary relations?
One.
One. There's no confusion at all. Case 2. All right. H is holding 80% of S1. S1 is holding 20% of S2. How many holding subsidiary relations?
One holding.
Only one? Only one?
Yes, sir.
Two.
How two? How two? Anyone? Those of you saying two. How? Between whom?
Sir, H and S1 and H and S2.
Knew the blunder. Knew the mistake that each one of us will do. Either on its own or together with one or more of its subsidiaries. Either on its own. On its own, H is holding in S1 how much? 80%. Correct? So is it more than 50%? Answer is yes. So is it a holding subsidiary relationship? Yes, it is. Now let's see H holding in S2. All right. So Srinidhi, pay attention. All right. H holding in S2. On its own, how much is it holding?
80%.
On its own, how much is it holding in S2?
0%.
0.
0%. Along with its subsidiary, how much is it holding in S2?
20%.
20%.
My math teacher says it is less than 50%. Less than one half. Is there a question of holding subsidiary here? Answer is no. There's still only one holding subsidiary. I knew where we will falter. I'm glad that we are making this mistake now, but not in the examination. I hope each one of us are clear here. Understood? Crystal clear? Yes. Now, case 3. Case 3. Case 3. I'm glad we are making mistakes. It's absolutely fine, but ensure that we don't repeat it. All right. H is holding 80% in S1. S1 is holding 20% in S2. H is holding 32% in S2. How much? How many holding subsidiary relations?
Two holding.
Two.
How many holding subsidiary relations? Rakshita.
Two,
Quick.
No, sir.
Only one. All right. So Rakshita says one. Let's see.
One.
All right. H to S1. Is it more than 50%?
Yes.
Answer is yes. So there is one holding subsidiary relation. H to S2. Let's see if there is a holding subsidiary here. On
Yes.
its own, how much is it holding? 32%. Along with its subsidiary, how much is it holding? 20%. Totally, how much is it? Greater than 50%. Is there a holding subsidiary relation?
Yes,
100%
yes.
there is a holding subsidiary relation here. Purposely, I've given the same example if you realize. Purposely, I've given the same example if you realize. Pay attention, pay attention, pay attention, everyone. Understanding? Crystal clear with the concept? Crystal clear with the concept? Yes.
Yes.
Yes, sir.
Case 4. Now, last one that I'm going to emphasize here. Pay attention, everyone. Let's make mistakes. That's absolutely fine. H is holding 80% in S1. S1 is holding 60% in S2. H1 is holding 60% in S2. How many holding subsidiary relations? How many holdings?
Two.
Think logically. If it was so obvious, I wouldn't have asked, right? If it was so obvious, I wouldn't have
3, sir.
asked.
3.
Vidula there in the session? H to S1, 1. S1 to S2, 2. H to S2, 3. Totally, I have 3 holding subsidiary relations. Understood, everyone? Crystal clear with the concept?
Yes, sir.
Yes
Yes,
or no?
sir.
Respond,
Yes,
respond.
Yes, sir.
Audible, friends? Is there a lag in the video and audio?
No, sir.
No, sir.
Clear, right? Everyone, can I get some response then?
Yes, sir.
Yes, sir.
Everyone crystal clear with the concepts? Everyone crystal clear with the concept? I am expecting questions from here. Everyone has made a note of the questions, right? During the session, I dictated around 6-7 different cases. I
Yes,
hope
sir.
you guys have made a
Yes,
note of
sir.
it. Everyone. All
Total
right,
11.
fair enough. I'm sorry, totally how many?
11, sir.
11, right? All right, fair enough. 7, 11, whatever it is. I hope you have made a note of it. Let's go to the next one. Associate company. Associate company means a company in which there is a significant influence. All right. So let's assume Pratiksha is holding 22% of Diksha. That means she is holding significant portion. She is having significant influence. Now, when I have a significant influence over another company, I'm called associate company. So what is the significant influence? If I hold more than 20% of total voting power, total share capital, or paid up capital, as the case may be, I will call such companies as associate company. Simple point, everyone. Understood? Yes, the language that we use here, extra focus is on significant influence. Extra focus on the point on significant influence. Next one. Government company. What is a government company? Sir, any company in which central government, state government, or a combination of central and state governments, or a combination of state governments as such, if it is holding at least 200% focus now, at least 51%. How is it different from subsidiary? In subsidiary, I just wanted more than 1/2. That was more than 50%. More than 50% is what I wanted in subsidiary definition. But in government company, I don't want just more than 50%. I want more than or greater than or equal to 1% of paid up capital. Here we are not using the language voting power. We are using the language paid up capital. Here we are not using the language voting power. We are using the language paid up capital. Small points, but makes a lot of difference. Shaya there, understanding? Yes, Mayuri, understanding? Foreign company under section 2 clause 42 now. What is a foreign company? Example, anyone? So we had discussed a couple of examples as well. Anyone able to recall? Elon Musk. At one point of time, he made a statement that I will never start a company in India. It's a separate story. Now he has his R&D center in the heart of the country, the tech hub. All right. It's a separate story that they has his business in Bangalore itself. So what are we trying to say here, sir? What are you trying to prove? I'm talking about a concept of foreign company. What is a foreign company? Foreign company has been defined under section 2 clause 42. Foreign company means a company or a body corporate which is incorporated outside India. That means it's outside India, but it is having a place of business in India, or and conducting any business activity in India. Both must be satisfied. It has to ensure that there's a place of business in India. Second, some business activity has to be carried out in India. In that case, if both of these, both of these conditions are satisfied, then I will call such companies as foreign companies. Understanding? Sleepy? Boring? There in the session? I repeat.
Yes.
What is this yes for? I didn't understand. Are you trying to say the session is boring?
No, sir.
Then it's fine. All right. Fair enough. So now listen to me very carefully. A company which is incorporated outside India, satisfying two conditions. First one, has a place of business in India. Anuya, yes, has a place of business in India and is conducting some business activity in India. If both of these conditions are satisfied, such companies are called foreign company. Now, Pratiksha is having one doubt. She says, sir, we don't do anything physically. We don't come down. We are doing it through our agent. Or let's assume we are doing it electronically. Emails. I can sit in Dubai and work for a company in India. Possible? 100% possible now.
Sir.
In that case, is it a place of business in India? I will consider that also as a place of business in India. Understood? Yes. So the language used is either through an agent, physically or through an electronic mode. If any of these conditions are satisfied, I will consider it as a company which is having a place of business in India. Understood? Everyone, where Lakshmi,
Yes, sir.
Prathamesh there, understanding? Viksha,
Yes,
crystal
sir.
clear? Now this is
Yes, sir.
about your, this whole discussion is about your foreign company. Can we proceed? The next one is Section 8 company. What is the Section 8 company, sir? Very simple. Pay attention to the details. What is Section 8 company? Those companies which are incorporated to promote charitable objects. Classic example. Anyone able to recall the example? Anyone able to recall the
Infosys
example?
Foundation.
Brilliant.
Foundation.
Brilliant. Infosys Foundation, if you remember, all right. Same example that we had given, which is having so many toilets which they have built. All right. They built so many washrooms, electronic washrooms in Bangalore, if you find, which is placed out at multiple public places. It is nothing but a Section 8 company. So what is this all about, sir? It is to tell that we are incorporated, but we are not here to make profits. What is our objective? Our objective is charity. We are here to promote our objective. Sir, let's assume I made some profits this year. Possible? Possible. Let's assume I'm charging 5 rupees per person's entry. I might be charging 10 rupees per person's entry. Now there is a profit here. Can I declare dividend out of it?
No, sir.
No, sir.
Don't even think about it. No dividend can be declared out of the profits of a Section 8 company. You cannot declare dividend out of a Section 8 profit, a Section 8 company's profit. All right. Next. Sir, what should we use, sir? Is it a limited liability? Yes, it is a limited liability. Should we use the words limited and private limited? Don't use. You don't have to use the word limited and private limited. Sir, who's going to give this status, sir? Central government is going to give the status. Now, they have better things to do. So they have given this power to ROC. All right. Now, ROC is going to grant the license to of a Section 8 company. Viksha, there in the session. Sir, what if you've yelled at the top of your voice? Can this license be revoked? 100% yes. 100% yes. If Section 8 conditions are contravened, or if the affairs of the company have been conducted to fraudulent or prejudicial to the public interest, then license can be cancelled. Understanding, everyone? Yes, crystal clear. Now, what will happen, sir, if the license is cancelled? Nothing, I funda. Shut up and start using limited and private limited. You are just like any ordinary company now. You are not anything special. Understanding? Shanuja there? She's Aujanya.
Yes, sir.
Manthan, Nivedita,
Yes, sir.
there in the session. Manju, understanding?
Yes.
Yes, let's continue. Suman, there in the session? All right. Now, next topic is dormant companies. Classic example for the classic crowd that I have right now. Yes. What is dormant company? As much as you guys are inactive, all right, such companies are dormant companies. What these companies you have to do? Nothing. Just make an application, tell them, sir, I'm useless. All right. This company does not do anything at all. Give me the license of dormant company. Now, Rochelle is thinking, sir, why will someone make this application? So that you don't have to follow so many rules and regulations which other active companies are following. All right. Whatever active companies are following, at least that headache I won't have. Are you guys understanding? In that case, you can make an application to the government, all right, to the registrar, and obtain the license or status of a dormant company. Now, when will I get this? If I'm formed and registered just to hold assets. Why? In future, I'll see, sir. If there is some business, I'll do some business in future. Right now, I don't want to do anything. This could be the first scenario. Second scenario, all right, it is an inactive company. If these both are satisfied, or any of these, if you're falling in any of these conditions, then you will be called a dormant company. 200% focus, extra important topic. All right. When first condition, where you're registered and you're just for holding assets for a future project, and you don't have any significant accounting transaction, Pooja there in the session, F64. If it is an inactive company, if any of these two conditions are satisfied, you will be called a dormant company. You make an application to the registrar, he'll give you the license or status of being a dormant company. What will happen if I get the dormant company status? You can relax. You don't have to follow too many rules and regulations. Why? Law recognizes you are inactive just as much as I am recognizing and acknowledging your presence right now. All right, let's go ahead with the next point. What is inactive company, sir? Inactive company means a company which has not been carrying on business, a company which does not have any significant accounting transaction in the last 2 financial years, a company which has not filed its annual return and financial statements during last 2 financial years. If any of these conditions are satisfied, you can call yourself inactive company. All right. Now, Shanuja is thinking, sir, what is the significant accounting transaction? I just passed an entry in the morning. Is that accounting transaction significant or not? I don't know. Significant accounting transaction means any transaction other than the following. Sir, if you're just passing these 4 transactions, those are insignificant. Those are not significant accounting transaction. That means you have better chances of applying. Saying, I am insignificant. I'm anyway not having significant transactions. You please give me the status of dormant. If you have significant accounting transaction, don't even think of calling yourself inactive because you are active. That's why you're having significant accounting transaction. Able to understand what I'm talking? Able to understand what I'm talking?
Yes, sir.
All right. Now, what are these significant accounting transactions? Sir, if you are carrying these 4 transactions, which I'm going to talk now, if any of these 4 transactions are only happening in your company, nothing else is happening, that means these 4 are insignificant. That means these are not significant transaction. If it is not significant transaction, it is good if you want to apply for a status of dormant company. Why? Because you're trying to prove that I'm having no active business. I'm not having any significant transactions also. Are you guys understanding? Are you guys understanding? Yes. So now what are
Yes,
these
sir.
significant accounting transactions? First one, where you're just there paying fees for registrar. Wow. You have no option. You have to pay fees to the registrar. If you don't pay, he will throw you out. He will start imposing liabilities and penalties. Second, where you've just made some payment. Sir, I paid taxes. Is that significant accounting transaction? No, that is not significant transactions. Sir, I've allotted shares this year. Is that significant accounting transaction? You have to allot shares. If you don't allot shares, how will you do business? Fourth one, sir, I paid some amount for office and records to be maintained. That you have to. If you don't maintain office, from where will you run the business? If you're doing just these 4 activities, it is not significant accounting transaction. Anything other than this is significant accounting transaction. So how do we correlate with dormant business? If you want to become a dormant company, you should not have significant accounting transactions. I hope I'm clear. I hope I'm clear, everyone.
Yes.
Understood? Understood? Yes.
Yes, sir.
Next is Nidhi company. So what is this Nidhi company now? These are companies under section 406, all right, where people come together for the purpose of, all right, these are incorporated with the objective of helping each other, bringing this habit of savings. And whenever the members need money, we can lend it to each other. All right. This is the whole objective of a Nidhi company. Example. So rather the definition of section 406 says Nidhi means a company which has been incorporated as Nidhi with the objective of cultivating the habit of thrift, savings amongst its members, receiving deposits from and lending to its members only for their mutual benefits and which complies with the rules which the central government has given. All right. So important thing that you will have to focus, objective is to cultivate habit of savings. Sleepy, Viksha there in the session? Viksha Vijay?
Yes, sir. Yes, sir.
All right. So where the objective is only for savings, first point. Second thing, where I am here only for the purpose after savings, if I have to help the mutual benefit of the members, I can go ahead and give money. These kind of companies are called Nidhi companies. Understood? Understood? Yes. Next one.
Yes, sir.
Next one. Spice. Let's add some spice to your life. Now listen to me very carefully. What is this spice? They've asked for 4 marks in examination. Write a short note on spice. What is spice? Simplified for incorporating these electronically. Or simplified, as the word itself says, I'm simplifying what? It is simplifying the incorporation of companies. How? By making the incorporation itself electronic. You don't have to go anywhere. I've given you the story as well. Earlier, to incorporate a company, we had to wait for months together. Why? Under the table, over the table, sides of the table, colorful money, all of those things used to come. Now law says nothing doing. Sit at your home, incorporate the company. You don't have to go anywhere. You don't have to go anywhere. This is the whole discussion on SPICE. So SPICE is an initiative of the Ministry of Corporate Affairs, all right, which is to ensure that there is ease of business. How? By ensuring that you can easily set up your business online itself by filling up all the forms on the portal. Do you remember I had shown it to you guys also on the portal?
Yes.
Just
Yes,
in
sir,
case if you're
yes,
not
yes.
able to, all right, just in case if you're not able to, let me quickly show it to you guys right now. Is the screen visible?
Yes, sir.
Yes, sir.
Yes, sir.
All right, let's see in case of it is, yeah. So can you see? There is company services, all right. So here you have the option of electronically incorporating the company as well. Let me know if you can see the screen.
So we are ready.
Yes, no, incorporation. You go here and you get all the steps that you have to follow for the purpose of incorporating your company. I hope I'm clear, everyone. Understood?
Yes.
Understood?
Yes, sir.
So this is the whole discussion about your SPICE. Now, write a short note or equity shares and preference shares. Now, again, another very interesting question. All right. What is equity shares? What is preference shares?
Preferential shares with the preferential.
All right. I might not be able to listen to everyone. Rather, let me answer this time since we are revising. All right. It becomes easier for all of us. There are two types of shares: equity shares, preference shares. Let's first understand equity share. Very, very difficult. Equity shares means
Which is not
those shares which are not preference shares. Wow. So difficult to remember. Equity shares means shares which are not preference shares. Then what is this preference share, sir? Preference shares has two things. As the word itself says, there's a preference. Preference means there's priority. Priority in terms of what? In terms of payment of dividend,
repayment of capital.
repayment of capital at the time of winding up. All right. So as the word itself says, sir, first thing, tomorrow, let's assume we have done good business. We want to declare dividend. Preference shareholders are going to get the priority. After that, if anything is left over, all right, it's like that eldest sibling at home, after, or like mother at home, after everyone has eaten, if something is left over, she will relish over it. All right. It's the same way. Preference shareholders will get all the preferences first in terms of dividend. After that, if something is left over, then probably the equity shareholders are going to enjoy. On your preference shares. Preference shares and equity shares, again, important from exam perspective. You should know because it can come in examination for a short note. Equity share capital means all the share capital, which is not preference share capital. Quite technical this is. Preference share capital means that part of share capital which carries, mute yourself, whoever it is, that part of capital which is having the word itself says, the law itself says, there's a preferential right which I'm giving. There's a priority which I'm giving. To whom? For what? For the purpose of payment of dividend, for the purpose of repayment of capital at the time of winding up. All right. At the time of winding up, whatever extra amount I have to pay, all right, that amount will be given first to the preference shareholders. And after that, if anything is left over, we're going to give it to the equity shareholders. I hope I'm clear, everyone. Understood?
Yes,
Understood?
sir.
Boring?
Yes,
Sleepy? There in the session?
Yes, sir.
All right.
Yes, sir.
So where is the definition of equity share and preference share coming? It's coming from explanation to section 43. Explanation to section 43 gives the definition of equity shares and preference shares. Understood? Amok? Yes. So let's continue. Next one. Three important doctrines. There cannot be a question paper without one question from any of these three. There will be one question at least from any of these three doctrines. First one, doctrine of ultra-vires, doctrine of constructive notice, and doctrine of endowment management. Let's understand each of these. First, pay attention to the detail. Sleepy, probably the last topic, so pay attention, everyone. Not last topic for the day, but last topic for the before the break. So pay attention now. Doctrine of ultra-vires. All right. Doctrine of ultra-vires says, sir, the company's MOA and AOA, Memorandum of Association and Articles of Association, are public documents. All right. They are public documents. Before they are public documents, I don't care. Can the company itself go beyond its MOA and AOA? Law says, wait, control. You cannot go beyond your MOA. Why? Limitation of action while I was discussing. If you remember, I clearly told you, sabka baap hota hai. Do you remember? Yes, everyone has a godfather outside. If forget about godfather, rather everyone has some screw is going to be the screw tightener. Am I audible? Yes. So what are we trying to say here? You cannot go beyond your MOA. No, sir, I want to go beyond my MOA. Congratulations, go. What will happen, sir? Nothing, I funda. Whatever you've done will be considered null and void. All right. Whatever you've done will be considered null and void. So tomorrow, let's assume you've gone ahead beyond your object clause. You are doing the business of software. You've gone ahead and entered into the business of real estate as well. Let's assume you purchased a property, huge profits you made in that property. Law says, wait, congratulations that you made profit. Now return the profit also. Why, sir? Who asked you to do the real estate business? You clearly don't to do the business of software. How did you get into the business of real estate? Why, sir? What wrong did I do? You nothing, I found out. You just I'm just applying the doctrine of ultravirus. You've gone beyond the MOA. Understood? This is the doctrine of ultravirus. Crystal clear, everyone? Yes, as the word itself says, you're trying to be over smart. What is that over smart? You're trying to be ultra. Ultra what, sir? Ultra wires. Wires means the power that I've given to you. You're going beyond the powers. Now come back. Don't wag your tail. I know how to tame. In case if you go ahead, I will consider the entire transaction to be null and void. Understood, everyone? Crystal clear? Yes. Now let's read the law. Let's read the law because in examination you can't not going to get marks for it. Pay attention. Let's see the language now. When an act is performed, it might be legal. Sir, entering into real estate business, is it illegal? No, it is legal. It might be legal, but if it is not authorized by the object clause of the memorandum or by the statute, it should be ultra vires the company and hence null and void. An act which is ultra vires the company cannot be ratified even by a unanimous consent of all the shareholders. Now, Lakshmi says, sir, your problem is I'm going beyond the MOA, right? I take the approval of all the shareholders, unanimous approval. What is all the shareholders 100% have agreed. No problem. Please go ahead and do real estate business. Law says, forget about shareholders. You went beyond your MOA. Even the shareholders cannot remove a defect which you have caused. Even the shareholders cannot remove this defect. Sir, no, sir, I've got 100% approval. I don't care 100%. You get 200%. I don't care. I hope I'm clear, everyone. Understood? Yes. Next, a company which is ultra-wise the directors, but intra-wise the company can be ratified by the members through a resolution passed at the general meeting. What is the meaning of this? Let's assume I've asked the director not to make a payment of more than 10 lakhs. If he wants to make a payment of more than 10 lakhs, he should take the approval of another director. Is making payments a legal business within my MOA? Yes, it is within my MOA. But there he has gone beyond his authority. Now, can I say I will not make the payment itself? Can that payment be cancelled? Wow. Imagine if it was your payment. If it was your payment, now you'll not give wrong answers. Why? Because your money is stuck, right? You will never give wrong answers if your money is stuck. Now listen to me. Law says, I understand. Since you are within the MOA, let the shareholders approve it and close the matter. I have no problem. Why? Because you're intra-wires the MOA. You've just gone beyond your powers as a director. But are you within the powers of a company? Yes. In that case, I will give you the permission. Ultra-wise, an act which is ultra-wise the articles, it can be ratified by articles by passing a special resolution at the general meeting. So what is the meaning of this? Sir, I'm within the MOA, but outside the AOA. Law says AOA, it's okay. Chalta hai. All right. In that case, please get the approval of the shareholders. I'll give you the permission. By what? By passing a special resolution. What is special resolution? At least 75% of the members should agree. At least 75% of the members should agree. General resolution or ordinary resolution, more than 50%, simple majority. Special resolution, more than 75%. Unanimous resolution, 100%. There can't be more than 100%. I hope you understand. All right. I hope I'm clear. Everyone. Yes?
Yes.
Yes.
Next. Now, you might be thinking, sir, okay, sir, I've gone ahead. I've entered into transaction. This is ultra-wise. Now what? Nothing. It will be void ab initio. Whatever you've done, injunction order can be passed against you. Court can ask you to stop doing this entire real estate business. Personal liability of the directors. Directors, you sell your kidney. You sell your house. Bring in the money. Bring in the money. All right. And the last point, criminal actions can be initiated against the members. All right. Whoever was involved, criminal actions will be initiated against them. Understood? Clear, everyone? Boring, sleepy?
No,
Yes.
sir.
All right, fair enough. Let's continue. You'll have to be very cautious while you're answering. Huh? Boring, sleepy? Yes. There in the session? Yes. Everything that I ask? Yes. Doctrine of constructive notice. What is this doctrine of constructive notice? Sir, my MOA and AOA are public documents. How do you know, sir? I've already shown it to you time and again here. Can you see the screen?
Yes,
sir.
Yes,
Yes.
sir.
Can you see something called view public document? Can you see
Yes.
something called view public documents? We have discussed this earlier also. Sir, you get the MOA and AOA of any of the companies that you want. Whichever company is incorporated, get their MOA and AOA. Now, when I've given you the access to the MOA and AOA, why don't you read those before entering into a transaction with the company? Why don't you read these documents before entering into the transaction with the company? Why? Sir, because it is as good as the company has given a notice. Example, Shrestha was about to sleep. Listen to me very carefully. I didn't say you're sleeping. I just said you're about to sleep. So pay attention. Now, let's assume Shrestha is into the business of, Shrestha Private Limited is in the business of real estate. All right. Suddenly, Shrestha realized nothing is happening in real estate. Let's do the business of software. I enter into a transaction with Shrestha for purchasing software from her. She has not made anything yet. Whose mistake it is? Shrestha is wrong. We agree because she's gone beyond her MOA. Am I also wrong? 100% I am also
Yes.
wrong. Why?
Yes.
Why?
Because
I
you did
should
not
have read the document. I
I
should have read the document. It is a constructive notice. Without reading document, I shouldn't have entered into a transaction. Now, since I have entered into a transaction, it is not going to be considered bad. I hope I'm clear. I hope I'm clear, everyone. Understood? Understood what we are talking about? Yes? Let's quickly read the law now. Boring?
No, sir.
No,
No,
sir.
sir.
Thank God for a change. You've said no. Let's go ahead. All right. Memorandum and articles, when registered with the ROC, they become a public document. They can be inspected by any person on payment of the nominal fee. Guys, I've practically shown it to you. Public document. Here you type the name of any of the companies, you'll get the details. I hope I'm clear, everyone. Understanding? Yes. So pay that nominal amount of 100 rupees, 200 rupees, whatever is the nominal amount, pay that and get the details. And then you enter into a transaction with the company. All right. Any person who wishes to enter into a contract with the company has the means of asserting and is presumed to know the powers of the company. Every person dealing with the company is presumed to have read these documents. I am presuming you've read these documents and then entering into a transaction with me. No, sir, sorry, I forgot. That's your headache. That's your headache. Why? Because the law wants the entire world to presume that you've read the documents and then entered into document transaction. That's why mutual funds and all, if you see, they clearly say, read the documents carefully before entering into any of the transactions. Why? Before subscribing to the securities. Why? Because it's your duty to read the documents, not my duty to come and show the documents to you. I hope I'm clear, everyone. Yes. Next.
Yes, sir.
Even if the party dealing with the company does not have actual notice, can you say that, sir, I didn't get the notice from the company. Company never came and gave me the MOA. It is as good as a notice itself. All right. It is a constructive notice. It is presumed that he has implied notice of them. How? Because it is available here. You should have read the documents and then entered into transactions. Understanding? There in the session.
Yes, sir.
All right.
Yes, sir. Yes, sir.
Person dealing with a body corporate, incorporated company or a society are bound to take notices of the disabled imposed by on the body corporates and its officials by the MOA, AOA, or other documents of the constitution. So whoever is entering into a transaction with the company, please read these documents carefully so that you can avoid the risk. The last doctrine is doctrine of indoor management. Now, what is this doctrine of indoor management, sir? Sir, internally, you will have 1,000 rules. Do you expect an outsider to know all of this?
No, sir.
This is what came up before Turquin's case law. All right. This rule, that's why it's called Turquin's rule. In examination, if ICAI wants to play around, they will give question, write a short note on Turquin's rule. Stumped. They're only bold. Thinking, what is this Turquin's rule? Is it doctrine of constructive notice? Is it ultra vires or indoor management? Pay attention. It is the indoor management that we are talking about. Understanding, everyone? Easy to remember. You are sitting in an IT city. So IT. Indoor Turquins. Easy to remember. All right. That's the least that I can think right now in this short span of time. All right. So we are sitting in the IT world right now. So I is indoor, T is Turquins. I hope easy to remember. I know it is lame, but somehow we have to remember for examination. That's the whole objective. All right. So what does this law says? It says person dealing with the company can presume that his internal rules, proceedings have been complied with. So now let's assume, all right, Viksha is entering into a transaction with Chaya Private Limited. Now, Chaya Private Limited has internal rules of regulations of ensuring before entering into a transaction, the company's director goes to the temple, then he comes to office. It is to ensure so that all the transactions are entered safely. Viksha can assume that the director has gone to the temple and then entered into transactions. That's like, how will I know their internal rules and regulation? How will I know? Am I even making sense? Everyone understanding? Sir, what you've told in MOA, I understand. What you've given in AOA, I understand. But their internal policies and procedures that they follow, how do you expect me to remember, sir? How do you expect me to check? Law understood your emotions, all right? Before you start crying, law said control. Doctrine of indoor management gives you the right to presume whatever internal rules, internal procedures, internal proceedings we have, that has been followed by the company. All right. You can assume that whatever internally they have to do, the checks and balances that they have to do, that has been followed. And this is going to save you from the doctrine of constructive notice. Why? Because tomorrow Chaya Private Limited might say, in my articles of association, I've told you that a director has to go to the temple and then enter into transaction. Why didn't you check if I've gone to the temple or not? Law says control. I know you've gone ahead. Chaya Private Limited might have all this, but I don't care. As an outsider, I will presume that it is your internal matter and internal proceedings have been followed. Understood, everyone? Understood, everyone?
Yes, sir.
Crystal clear?
Yes, sir.
Right?
Yes,
So,
sir.
this doctrine is based on business convenience and justice. This is the protection to the person who is dealing with the company. Business cannot be carried on if there is a requirement that everyone who deals with the company has to ensure that the company's officials had the requisite authority. All right. An outsider is presumed to know the company's constitution, but he cannot be presumed to know what may or may not have taken in its internal administration. Sir, what are the exceptions of indoor management? 4 exceptions, again asked in examination often. That means the following 4 are arising, then you can't say that it is an internal proceeding, so I don't care. That means you have to check if any of these are there. If any of these, though you are an outsider, though Viksha is an outsider when it comes to Chaya Private Limited, but Viksha, if she is falling under any of 4 of these cases, she cannot claim indoor management. What are those 4? First one, knowledge of irregularity. Viksha knows that Chaya Private Limited has some irregularity, still she's entering into transaction. That means it's her mistake. She knows that there is something wrong. Every year she's been ensuring that she gets the signature of 3 members, 3 directors. This year there's only a signature of 1 director. Why? You are not having knowledge of irregularity, but still you're okay with it. That means I will not let you go ahead with it. Next point. All right. No knowledge of articles. Without reading the articles itself, if you enter into transaction, that means it's your blunder. Why? Doctrine of constructive notice clearly says, read these documents at least before entering into the transactions. Next one. If there's a forgery, and you're aware of it, all right, and still if you enter into the transaction, there is your problem. That is your mistake. And the last one is negligence, where Viksha has been negligent. She didn't even bother. She's like, sir, whatever it is, make the payment. If there is some negligence, then doctrine of indoor management cannot save you. Then indoor management cannot save Viksha in this case. Understood, everyone? Understood, everyone?
Yes,
Crystal
sir.
clear? Yes.
Yes, sir.
Yes, sir.
Exactly 1.5 hours that we've spent on revising the entire Companies Act, which during our session, we might have spent easily 6 hours or more than that. We've revised it in 1.5 hours. Possible, 100% possible. Now, let's quickly take a break of 10 minutes. It's 5:30. Let's be back by 5:40. We continue the next chapter, partnership. All right. Extremely important. Guys, I'll take all the doubts probably at the fag end, because this session is purely to revise, not to entertain all the doubts. But nevertheless, I'll take all the doubts. Let's just park it till the end of the session, or maybe tomorrow you make a list of all the doubts. I'll take all the doubts in the next session. All right. So let's get back by 5:40 and we start with partnership. Again, come back 100% energy.
Okay, sir.
All right, everyone's back. Let's get started.
Yes, sir.
Yes, sir.
Yes, sir.
Audible? Visible?
Yes, sir.
Yes, sir.
Yes,
Yes,
sir.
Comfortable with the pace, friends? Everyone comfortable with the
Yes, sir.
speed?
Yes, sir.
Appropriate? Can we continue? Yes. All right. Let me know if you can see the screen. Is the screen visible?
Yes, sir. Now it is visible.
All right. So first thing, I hope each one of you have got the material that is being displayed right now. You've got the
Yes.
soft copy of it, right?
Yes, sir.
Everyone?
sir.
Yes. All right. Fair enough. So this is more or less the updated one. There are a few amendments which have come up. So that those also we have captured as a part of this entire material. So in LLP, there are significant amount of amendments, which we will see when the LLP comes up. So now we are done with the first topic. We're going to the second one, which is pertaining to entire discussion on your partnership. All right. So what exactly is partnership? How are the partners going to be associated? What is going to happen in terms of partnership? All of these things, again, like we have discussed in the past, we're going to look into it in detail. Let's get started. Can I start? Yes. Insist you to keep your
Yes,
cameras
sir.
on.
Yes, sir.
Yes, sir.
Insist you to keep your cameras on. Let's get started. All right. So important topic again. There cannot be, if you were to ask me, the importance of partnership is more than Companies Act. All right. From your perspective, from your syllabus perspective, from the coverage and scope perspective in examination, questions on partnership are going to be even more in terms of the number of marks, more than your Companies Act. I hope you're understanding what I'm trying to say. So don't you dare think about compromising on ensuring that you spend good amount of time on this chapter. You will have to ensure that you spend good amount of time on this chapter. Understanding, everyone. Insist you to keep your cameras on. Don't expect me to do this every now and then. All right, let's get started. Is the screen visible? Yes.
Sir. It is visible.
Yes, sir.
All right. So the topic now is Indian Partnership Act. Again, 1932. Why is it important? Is because this is one of the act which came up before your independence. All right. So this is a pre-independence act, which is talking about various things which a partnership has to follow. All right. Now, there's the first thing that we discuss is what is partnership and where is it coming from? Section 4 defines your partnership. Pay attention. Section 4 defines your partnership. So there's something different about the section numbering. If you see, most of the definitions come under Section 2. But when it comes to partnership, the definitions are coming under Section 4. All right. So let's get started. What exactly is partnership and how does it work? Partnership is a relationship between two or more
Only
persons.
Relation between
Only
the
relation between.
This is the beauty of attending sessions. All right. I didn't have to spend much time. I hope for those of you who aren't able to understand what our friends, others have just mentioned, sir, this is not your relationship with your respective spouse or your girlfriend, boyfriend, as the case may be. We are talking about a relation. You don't build your ships and boats. It is appropriate in itself. Relation. Ships not required right now. It is important because in examination, if they're asking you to write definition, and if you end up writing statements like relationship between two or more persons, they've already used the word persons. It is plural. My English teacher has already told me persons means it is plural. Two has to be there. There cannot be 1.5 person. I hope I'm making sense, everyone. Understanding? Yes. Now it might be funny. Right now, each one of us are laughing. But in examination, in the flow of R, you might end up writing with relationship, two or more persons, all that. Trust me, if it is definition. And if you have some cranky evaluator, trust, good luck. Glad that it's not me. If it was me, I would have gone ahead and scratched the entire answer. All right, you're lucky. Don't worry. So it is a relation between persons. For what, sir? So that they have come together for the purpose of sharing the profits. Profits of what, sir? Of a business. Sir, who should carry on this profit business? carried on by all or by any of them acting on behalf of all. Extremely important phrase because this gives us reference to mutual benefits and mutuality as such, which comes into picture. Understanding everyone, which we are going to discuss, don't worry. All right. So the entire discussion of your partnership, how it works, how it does not work is coming from here. What is a partnership? Partnership is a relation between persons who have agreed to share the profits of a firm, of a business, which is carried on by all. All of us can agree to carry on, or by any of them on behalf of all. All right. Now, this is the definition of partnership. Persons who have entered into partnership are called partners individually, and collectively they are called a firm. And the name under which they are running the business is called firm name. As simple as that. Understood? I repeat, insist you to keep your cameras on. Don't expect me to do this every now and then. It is annoying after a point of time. Next. Can charitable institutions or clubs start their partnership? Answer is no. Why? Sir, because here we are only for profits and we have clearly told there must be profit. Fine. So can two companies come together and start the partnership firm?
Yes.
Answer is yes. Why? Because it's a relation between persons. Have I mentioned natural persons?
No, sir.
I've just mentioned persons. It could be natural, it could be artificial, it could be anything. So I hope you understand. Even if it is artificial person, can they carry out a partnership? Answer is yes. Answer is yes. Understanding? Now, sir, can two partnerships come together and go ahead and start their business?
No, sir, because
answer is no.
Agreement.
Please note, when it comes to partnership, partnership is just an agreement. It is just a result of an agreement. It is not a legal entity which is coming into picture. So therefore, can Sri Saujanya and Co. and Amog and Co. come together and start Sri Amog and Co? Answer is no. Not possible. Why? Because two partnership firms cannot start a third partnership firm. Both of them do not have any separate legal entity. Understood? This will be everyone. Yes, can we continue? Yes. Now, partnership deed. Again, asked in examination, write a short note on partnership deed. What is partnership deed? Partnership agreement. Partnership is a result of an agreement. That agreement could be verbal, could be oral, could be in writing. Anything is okay. If it is in writing, it would be preferable to do it on a stamp paper, which is stamped under the Stamp Act. And once it is stamped, we bring it under the legal records, and that is called partnership deed. So what is partnership agreement? It is just a colloquial agreement. It could be verbal, it could be anything. All right. But if it is being written and if it is being stamped, then I call it as a partnership deed. Understood? Yes. Language, agree. I repeat, partnership agreement, verbal. Partnership deed, writing and registered under the Stamp Act. Then it will be called partnership deed. Understood? So now what is this partnership deed, sir? Sir, it is that document which is talking about where we are and what are we going to do in the entire business. All right. In simple terms, it is a combination of MOA and AOA of a company. Similar to a combination of MOA and AOA. Everything is mixed and brought under one document, which is called your partnership deed. Understood, everyone? Yes. So next point that we have to discuss is duties and relation of the partners to a partnership firm. What is their relation? Are they here for the purpose of carrying business? 100% yes. So the first thing is, sir, the duties to carry on the business to the advantage of the firm, not individual personal advantage, but the advantage of collectively all the partners. Second point, sir, we are here. We'll have to ensure it's our duty to be just and faithful, to render true accounts and full information, duty to indemnify for the losses which are caused by fraud. If there is a fraud who is committed, if you have committed, it is your duty to indemnify for the losses which are arising out of it. The next point is, sir, if it is our duty, rather it is our duty not to carry on other business when there is a restraint in the contract, when we have clearly agreed that you're not going to carry on any competitive business. And if you still carry on, then I will not permit you to do so. All right. That will not be permissible. The next point is not to act, or rather duty to act diligently, not to claim remuneration, contribute for the firm's losses, indemnify for the loss due to willful neglect. So these are the various duties of a partnership firm. These are the various duties of a partner in a partnership firm, rather. Now, what are the rights of a partner? Very important. The following are the rights of the partner. The first one, right to take part in the business. You are a partner. Don't you think it's a right to take part in the business? Now, please note, in examination, this might often happen that you might get confused between duty and right. What is duty? Duty is something that you have to do. It's your responsibility. What is right? Right is the power that you get because of the position that you occupy. Am I making sense, everyone? Yes, I repeat. Duty is your responsibility. Right is the power that you get out of your position. So the first thing that we saw is to take part in the business and consultant, to have access to the books, equal share of profit subject to the partnership deed. If nothing is mentioned in the partnership deed, it is assumed that you're right to ensure that you get equal profits. Understanding? Boring? Sleepy? There in the session?
There in the session, but not serious.
All right. Next one. Sir, it is your right to receive interest on capital. It is your right to receive interest on advances, indemnification by the firm for protecting it from loss, and entitled to use the firm property for the business of the firm. All right. So these are the rights. Now, interestingly, they'll ask this question in examination. All right. If you have given an advance in the partnership firm, can you claim an interest? 100% yes. Sir, if nothing is mentioned, what should we do? 6% is going to be the amount. Important. 6% is going to be the amount that you can claim as an interest on advance. MCQ, 1 mark you can expect here. All right. Next one. Partnership property. 200% focus, expecting a question here. What is this partnership property? All right. There are two properties. Let's assume. All right. Lekha, there in the session? Respond.
Yes.
All right. So who's Lekha amongst you? Between you, who's Lekha?
Sir, myself, Lekha, sir.
All right, fair enough. Although I didn't understand who was saying myself, nevertheless, let's assume Lekha there in the session. So let's assume Lekha, all right, is one of the partner. Lekha is one of the partner in Gaya, Lekha and Co. All right. This is the partnership form. Listen to me very carefully now. There are two properties. One is going to be Lekha's personal property. The other one will be the property of the partnership firm. It is important to distinguish. Why? Because tomorrow, if anything happens in the partnership firm, which property should be used first? Partnership firm property. And after that, if I don't have sufficient property, then I will go to Lekha and recover money from her as well. But if there is no distinguishing, if I am not able to differentiate, that means Lekha's property is also partnership property. Then Gaya is going to enjoy the entire rights here. Let's assume Gaya gets nothing in the entire partnership. All right, she does not get any assets. Tomorrow, if anything happens, you will be using Lekha's property for the purpose of repayment. Is it even fair? Answer is no. Therefore, law gives under section 14. Let's first talk about what is partnership property. Partnership property has been defined under section 14. Partnership property of the firm includes all the partners, all the properties which the partners have brought in the form of their contribution to the common stock, which is nothing but capital, which is nothing but the capital. Understanding, everyone? Yes, the first point. Second, all the properties, rights which are acquired by the firm for the purpose and in the course of business of the firm. All right, let's assume we have purchased some properties. That is also the partnership property. And last one, very important, goodwill of the business. This is also the partnership property. Very important. Goodwill of the business is also the partnership property. Why is it important to distinguish? I've already told you. Tomorrow, let's assume the firm has to pay something. All right. Should I use the partnership property first or the partner's property first?
Partnership property. And then if anything remaining,
very obvious. I'll be using the firm's property first. After that, if there is anything remaining, then I'll be using the partner's property. All right. So this is what section 14 is all about, to ensure that you have a clear distinction in whose property each of these are. Personal profits earned by partners. Very, very important topic from exam perspective. All right. Let's assume, according to section, if a partner is deriving 200% focus, if a partner derives any profit from any transaction of the firm, from using the property of the firm, from using the business connection of the firm, or by using the firm name, he shall account for that profit and pay it to the firm. If I'm using any of the firm's property and generating profits, that profit does not belong to me. It belongs to the partnership firm. Please give that profit to the partners. All right. This is the first point. Second point, if the partner is carrying on any competitive business, which is of the same nature, all right, let's assume we are in the business of real estate. Amog and myself are in the business of real estate. Amog is also having a personal business of other real estate business also. What is he doing? He's competing with me. He's competing with me. Law says, wait. All right, if you're doing something, he shall account for all the profits which he has made in that business. Entire profit that he's made in that business has to be accounted in the profits of the partnership firm. Understood, everyone? Understood, everyone? Very, very important. Very important. This is about your section 16. I hope I'm clear. All right. Section 17 talks about rights and duties of the partners after a change in the firm. All right. Once there is a change in the firm, sir, how will the firm change, sir? It could be because of new partner. It could be because of outgoing partner. It could be because of the change in the partnership property firm, change in the partnership period, change in the business. In that case, what about the rights of the partner, sir? Rights of the partner will continue being whatever the rights were there earlier, unless and until if we have ourselves agreed to change it. All right. If we have ourselves told that no, we don't want to continue the old rights anymore. All right. We want to change it, then follow the new rights. If we haven't spoken anything, then we'll use the old rights itself. Understood, everyone? Yes, Gangotri there in the session. Understanding?
Yes, sir.
Understood the concept, everyone? Yes, where Lakshmi? Can we continue? Next.
Yes.
Where there is a change in the firm, expiry of the term, and where additional undertakings are carried out, the rights and duties will remain the same as they were immediately before the change, unless anything which has been prescribed in the agreement. All right. If we ourselves have changed the deed, then you follow what is given in the deed. Understood? Understood. Last year there in the session. Understanding? Now, relation of the partners to the third parties. Relation of the partners to the third parties. 200% focus. Extremely important topic. First point, partners are agent of the firm under section 18. 200% focus. Partners are an agent of the partnership firm. They are the agent of the firm. Am I making sense? Am I audible? Am I audible, everyone?
Yes, sir.
Yes,
Yes.
Partners are, listen to me very carefully. Partners are agent of the partnership firm. What are we trying to say, sir? When you remember the definition, I clearly told you, partnership is a relation between partners, between persons who shall share the profits of the business which is carried on by all or any of them acting on behalf of all. What is the meaning of this acting and all this? What acting are we talking about? This we are trying to say that let's assume Fiksha, Tejaswini and Sri Saujanya and myself, all four of us have started a business. It's a partnership firm. Looking at how active these three are, probably I might have to carry on the entire business. Can I do so? 100%. No, I won't. Sri Saujanya has decided she will carry on the entire business. All right. Now, can she carry on the entire business on behalf of all of us? Answer is yes. Now, in that case, Sri Saujanya becomes the agent of the partnership firm. This is what section 18 says. It is a superpower that I'm giving you, that you are an agent of the firm. All right. So whatever you do in the name of the firm, all right, very important, you should do whatever you're doing in the name of the firm. It is as good as the firm itself has done it. Understood, everyone? Crystal clear with the concept? Yes. So section 18 says a partner in the agent is the agent of the firm for the purpose of the business of the firm. However, this cannot be applied to all the transactions and dealing. It is applicable only on those which are done for the purpose of the business of the firm. Very obvious. Whatever is to be done, that has to be for the business of the firm. Then it will be considered as she has done, Saujanya has done for the purpose of, on behalf of the firm, and she is an agent of the firm. This is what section 18 says. Wait. Section 18 says Sri Saujanya is an agent of the firm. Now pay attention, pay attention, pay attention. Section 22 says whatever she's done, all right, before section 22, rather section 19 says, pay attention. Section 19 says, mute yourself, whoever it is. 18 says, 18 says, Sri Saujanya is an agent. 19 says, I'll give you a superpower. What is the superpower? Whatever you do, you can go ahead and bind all the other partners. All right. The same statement. This is a superpower. But along with this superpower, there's a super responsibility. What is the super responsibility? We'll talk later. But what is the superpower? You have the power to go ahead and bind all the partners of the firm. Let's assume Sri Saujanya has gone ahead and sold a property of the firm. All right. She's gone ahead and sold the goods of the firm. Keep aside the property. She's gone ahead and sold the goods of the firm. Is it going to be considered as the sale by the firm? Yes.
Yes, sir.
Are other partners also bound by it? Yes.
Yes.
This is what section 19 says. 18 says she's an agent. 19 says whatever she does is going to bind all the other partners also. 22 says, sir, how should we bind, sir? What is the mechanism? How to implement the superpower? Agreed. Whatever she does is going to bind the other partners also. But how to apply this power? This is coming under section 22. It says, first, it should be done in the name of the firm. Second, in any other manner to show that it is an intention to bind the firm. Two things. First, it should be done in the name of the firm. Second, you have to prove it somehow that I have an intention. Sri Saujanya has to prove it somehow that I have an intention of binding the entire firm. What is firm after all? Collectively, all the partners are called firm. What is firm? Firm is nothing but collection of all the partners. So Sri Saujanya has to prove it that whatever she has done is for the firm as such together. Now, these are the two conditions which are going to be ensured. And once these two conditions are satisfied, it is as good as section 19 comes into power. Understood, everyone? Crystal clear with whatever we've discussed, everyone? Yes. 18 says Sri Saujanya is an agent. 19 says I will give you a superpower. What is the superpower? You can go ahead and bind. 22 says, how should I bind the partners? What is the mode of binding the partners? That is possible by only two ways. First, ensuring that it is in the name of the firm. Second, by ensuring that everything that is done, it is to show an express or intention to bind the firm. Sleepy, Pratiksha, then in the session?
Yes, sir.
Exceptions, the following restrictions are there. Act must relate to the usual business of the firm. Pay attention. Whatever she does has to be in the usual business of the firm. It should be for the normal conduct of the business of the firm. It should be in the name of the firm or an intention to be the firm. First 2 points discussed now. 200% focus. Sleepy, there in the session?
Yes.
Can we start? Yes.
Yes, sir.
All right. First one. It says, sir, it should be for the normal or usual business of the firm. What is the usual business? Let's assume we are in the business of real estate. Suddenly, Sri Saujanya gets into the business of purchase and sale of software. Is that usual business?
No,
Answer
sir,
is
it
no.
is not
That's
the
not a non-usual business. What is our usual business? Our usual business is the normal business that we've been doing of real estate. Suddenly, she gets into software. Can she bind us? Answer is no.
No, sir.
She cannot bind us. Second condition. It should be for the normal conduct of the business of the firm. What is the meaning of this? Normally, whatever you're going to do as for conducting the business, that if you're doing, we have no problem. One fine day, you have sold the building itself from which we are selling the properties. Is it normal? No, that is not normal. That is abnormal because you've sold the place from which we sell. This is abnormal. This is an extraordinary activity which you have done. Is it going to be binding the firm? Answer is no. You cannot bind us because you've done something which is not the normal business that we do. Normal conduct of the business is to sell goods, but you've sold the building itself from which we sell goods. Wow. That is control. I'm not going to give you the permission to do this. And the last one is you have to do whatever you are doing that has to be in the name of the firm, or else you cannot bind the firm. These are the three conditions. Until and unless these are satisfied, you cannot go ahead and carry out the entire binding of the firm as such. Understood? Yes. 18 says, what is an agent? 19 says, it's a super privilege that I'm giving you so that you can bind the entire firm. 22 says, how to apply this entire law. Understood? Yes. Now, next point. Let's go ahead. Section 20. Sir, can we extend or restrict this power? Can we extend or restrict this power? Answer is yes. Can we extend or restrict this power? Answer is yes. This can be extended or restricted. But how do you do this? That is also important. All right. How do you do this? That is also important. Law says the implied authority of the partner may be extended or restricted. Just give me a second. Just give me a second. Audible?
Yes, sir. Audible.
All right. So extension and restriction of this authority. Sir, how do we extend and restrict this? The implied authority of the partner may be extended or restricted between the partners. All right. So we are going to agree that we are going to restrict it. We are going to either extend it or restrict it. But is the third party covered by that restriction or extension? If he's aware of it, then he's covered by it. If he's not aware of it, he's not covered by it. What is the meaning of this, sir? Sir, let's assume Ramakrishna is one of the partners in our firm. All right. Going by whatever we've discussed, Ramakrishna can go ahead and purchase the goods. But one fine day, we decided Ramakrishna should not purchase the goods from now on. He's still gone ahead and purchased the goods from a third party. Till now, from same vendor, he's always been purchasing. We had no problem. Tomorrow, again, he goes to the same vendor and purchases. Is the third party bound by this extension or restriction that we've imposed on Ramakrishna? Answer is no. He's not bound by it. Why? Because he wasn't aware of it. But once he gets to know, once we have shared the notice to that third party also, look, Ramakrishna might be coming to you for purchasing goods. Please don't give it to him. If he's aware of it, still if he goes ahead, that means it's his mistake because we've restricted the rights, but he is not adhering to it. Understood what we are talking about? Understood what we are talking about? Understood? Yes. So this is about your section 20. All right. So what is the language? Implied authority may be extended or restricted. Under the following conditions, the restrictions imposed shall be effective against the third party also. So there can be a question. Write a short note. When will restrictions be effective against the third party? When will restrictions imposed on a partner be effective against the third party? So when is it going to be? First two cases where the third party knows about the restrictions and third party does not know that he is dealing with the partner of a firm. Second case could be where he thinks that the other person thinks that Ramakrishna is coming and purchasing goods on his personal account, not for the firm. That is what the second point is all about. That is what is the second point all about. Understood, everyone? Understood, everyone? Yes. Can we proceed?
Yes, sir.
Next point. Notice to the acting partner. Section 24 says, sir, if you've given a notice to the acting partner, all right, whoever is habitually engaged in the act of business of the firm, language, habitually acts in the business of the firm. If you've given a notice to such person, it is as good as notice given to the entire firm. Have we used the language active partners here?
No, sir.
No, sir.
Even after me making the statement, still most of you in your examination, if you end up writing active partners, your answers will be scratched. Your answers will be scratched. Am I making sense, everyone? Notice is not to the active partners that we are talking about. If you are giving a notice to a person who habitually acts on behalf of the firm, ideally it is the active partner itself, ideally. But since the law is not using this language, let us also not use the language. Habitually acts in the business of the firm. If you're giving a notice to such matter, I will consider it as a notice to the firm. However, there are exceptions.
Fraud.
What is the exception? The first exception is in case of fraud. All right. If you have gone ahead and given the notice to that partner, what is the fraud? Fraud is where the partner is also involved in it. And what you've done, you've given the notice to such fraudulent partner. And tomorrow you're saying, I had given the notice to the firm. You didn't take an action. Law says, wait, you gave the notice to the partner who was indulged in the fraud. It will not be considered as a notice to the firm. It will not be considered as a notice to the firm. Understood? Understood, everyone? Crystal clear with the concept? Yes. This is what section 24 is all about. Next, liabilities of the partner. Sir, what all will the partners be liable for? 200% focus. Failure of general duties, indemnify for the losses, contribute to the losses equally, indemnify for the willful neglect, surrender your profits, account for the profits from competing business, jointly and severally liable for all the acts of the firm, and liable to the third parties for the acts of the firm. In simple terms, whatever we've been discussing about the liabilities earlier is nothing but getting summarized here. Next point. Rights and liabilities of minor partners. All right.
So minor being agreed to the benefits of partnership firm.
Even after yelling for hours together, if even now you use the language minor partner, you will have to brush yourself, your cheek with your hands. All right. All that you'll have to do is not brush, but slap. There is no language called minor partner. Time and again, we've seen this. But even after this, today, now in this session itself, people were nodding their head. Why on earth were you nodding your head? I don't understand. But nevertheless, I hope you understood what I am trying to make here reference of. Raksha, there in the session? Yes. So what am I talking about is a scenario where we are talking about the rights and liabilities of minor partner. Sir, first thing, there cannot be minor partner. You cannot use the language minor partner. Sleepy, Mayuri, there in the session? Yes. So what is the language, sir? Section 30 says a minor cannot be bound by a contract because a minor's contract is void. Sir, very obvious basics. Sir, then what are you talking about? I am talking about a scenario where minor is admitted to the benefits of partnership. That's it. He's not a partner. He's just going to come, enjoy the benefits and go. Anyone? What example were we talking about? Anyone?
Saif Ali Khan's
Quick.
Saif Ali Khan's song.
Now all of these examples, 100% everyone will remember. I'm glad that you remember because that's the whole concept that we want to turn around here right now. So Taimur, that was the example that we had taken. Who he is, let's not bother, some child celebrity. All right. He wants to become a partner in your firm. First of all, can he become? Answer is no.
No, sir.
But using his name, if you start selling your product, imagine the marketing that you might end up doing. All right. Imagine the market that you might be solving. Law says, fair enough. I'll give you the permission. Can he become a partner? No. But he can be admitted only to the benefits of the partnership. That means if he wants to join, he will join only in a scenario where he's going to enter, enjoy the benefits, no liabilities, and leave the firm. He's not going to suffer any of the losses. If he's coming only for the benefits and he's going to leave the firm. Right? Because he's a minor. He doesn't understand. He will not bear the losses anymore. No. What is this section 30 talking about? Section 30 says, sir, minor cannot enter into contracts. Therefore, a minor cannot become a firm partner in the firm as well. Though a minor cannot become a partner in the firm, he can nonetheless be admitted to the benefits of the partnership under section 30, something that we have already spoken about. All right. Now, what are the rights of this minor partner? Rights of the minor partner.
Sir,
Sir,
minor
minor cannot be partner.
Where are you guys? There in the session or not?
Yes, sir, we are there.
Doesn't seem like you guys are there. Repetitively, I've just 30 seconds back, I've told you, you cannot use the language minor partner. Now you'll tell, sir, on screen in the document, you have only used. The whole point was purposely used to get a fair idea of, are you able to understand? Listen to me very carefully. Partner being admitted to the benefits of partnership or minor being admitted to the benefits of partnership is the language that we use. All right. Now, please note, what are his rights? He has a right to share in the profits of the firm. He can come, inspect, and check the copy of the accounts of the firm. He can sue for the accounts of the firm, but only when, wait. He can sue for the accounts of the firm or for payment of a share, but when? Only when he's severing his connection and not otherwise. Again, this was also discussed while we were discussing during our session, if you remember. Can he file a case randomly? Answer is no. He can file a case only when he's no more associate. When he's moving out of the firm, only then he can go ahead and file a case. Do you remember, Akshita? Yes, there in the session. Understanding? Now, on attaining majority, what should he do? Celebrate birthday? No. Apart from that, what is he supposed to do? He is supposed to take 6 months and decide what he wants to do. If he wants to continue, fair enough, he's going to be liable to the firm's liabilities as well. After attaining majority, whatever the firm is attracted, be liable. But in case if he decides not to go ahead, listen to me very carefully. If he decides not to continue as a partner in the firm, what should he do? He has to continue. He has to ensure that he serves a notice to all the third parties to clearly tell that he is not going to be associated with the firm. Why? Sir, if he forgets, then it will be assumed that he's a partner in the firm. Then he's going to be assumed as a partner of the firm. Understood, everyone? Yes, quickly, let's read the law. On attaining majority, he may within 6 months elect to become a partner or not become a partner. If he elects to become a partner, he is entitled to the share which he was entitled as a minor as well. If he does not, then he shall not be liable for any of the acts of the firm after the date of public notice served to that effect. So he's not going to be liable as long as the notice is given. If the notice is not given, then he's going to continue being liable for all the debts of the firm as well. Understood? Crystal clear? Expect a question from this region. Expect a question from this entire topic. All right. Now, what are the liabilities? Before attaining majority, is he liable for something? His liability will be only to the extent of his share in the profits. All right. Minor has no personal liabilities. Can you ask him to sell his kidney and bring in money? First of all, he's minor. He's not even a partner in your firm. He's just admitted to the benefits. Can you ask that Taimur to go ahead and take the personal responsibilities? Answer is no. Nothing is going to work out that way. Understanding? Yes. The third point is minor cannot be declared insolvent. So let's assume one fine day Taimur says, sir, even I don't have money. Forget about personal liability. I don't have money, even otherwise also. Can you declare him insolvent? Answer is no. You cannot declare him insolvent. All right. Now, after attaining majority, what is his responsibility? Once he attains majority, and once he gets to know the knowledge of that, he has been admitted to the benefits of partnership. He has to decide, and he has to continue. He has to decide whether he wants to continue or leave the firm. Within 6 months, he has to take this decision. Where he has elected not to become a partner, he may give a public notice that he has been elected out. If he fails to give this notice, he shall be liable for all the debts which are attracted on expiry of the 6 months. Immediately after 6 months, whatever is there, he's going to be liable for it. Understood? Understood, everyone? Yes,
Yes,
crystal clear?
Yes, sir.
Next point. Legal consequences of partners coming in, partners going out. All right. Section 31 says, no person shall be introduced as a partner into the firm without the consent of all the existing partners. That means, pay attention. There are
Unanimous.
4 partners. There are 4 partners. All right. We want to admit another partner. 3 have agreed. The 4th one is not agreeing for the admission of this partner. Is it okay?
No, sir.
No, sir.
Unanimous.
I've got majority. Majority of the partners have agreed. Is it okay?
No, sir. It is
No,
not
sir.
all.
100.
All the partners.
Not okay. Why? Because all the partners, again, this was also asked in one of the examination and student got stumbled because they saw out of 4, 3 are agreeing, more than 50%, majority of them are agreeing. How can you stop? Thus is control. Whenever you're introducing a partner or any partner is leaving out, ensure that you get the approval of all the partners and only then that person can move out or come in. Understood? Understood, everyone? Even
Yes.
after making this, I am still expecting someone to do this blunder. Please don't. I hope I am clear, everyone, crystal clear with the concept as well. All right. So let's read it once again. No partner shall be introduced as a partner into the firm without the consent of all the existing partners. A person who is introduced as a partner in the firm does not hereby become liable for things which are done before he became a partner. Very obvious. He is not going to be liable for things which arose even before he became a partner. Will he be liable? Answer is no.
No, sir.
But will he be liable for things which has happened after his entrance? Answer is yes.
Yes, sir.
That is very obvious. Understood? Understood? Yes.
Yes,
Now,
sir.
expulsion of partner, section 33. Example, anyone? Anyone?
So that birthday party, Shah Rukh Khan comes and
Simple. Shah Rukh Khan comes. I'm sorry.
Salman comes.
Salman Khan, Shah Rukh Khan.
Amitabh.
Am I audible?
Yes, sir.
Yes, sir.
Which Bollywood movie scenes are you talking about? I don't know. But let's assume, all right, it's a scenario where you and I are partners in a partnership firm. All right. Our respected spouses have gone ahead and fought. Of course, the scene was of a party itself. All right. Now, I am convincing our third partner also to throw you out of the firm. Why? Because your spouse fought with my spouse. So we will convince the other partner, both of us majority, throw you out of the firm. Is it possible?
No, sir. It is
No,
not
sir.
good faith.
Section 33 comes into picture. That partner cannot be expelled merely because I have the majority. I cannot throw him out. Why? Unless it is in good faith. It should be in the good faith of the firm. It should be in the favor of the firm. Only then I can throw him out, or else there's no question of throwing him out. Understanding, everyone? This is the first thing. Next. So what is the procedure? Expulsion should be in the interest of the partnership. The partner should be given a notice and he should be given an opportunity of being heard. Only if these 3 conditions are satisfied, this person can be thrown out, or else you cannot. I hope I'm clear, everyone. Understood? Understood, everyone? Yes. Now, insolvency of a partner under section 34. All right. If a partner becomes insolvent, what is going to happen? The moment a partner becomes insolvent, his property will be held by the courts. All right. The official signee will come into picture. He's going to hold the partnership. Immediately after he's declared insolvent, he will be terminated from the partnership. So it would lead to the dissolution of the partnership, not the dissolution of the firm. I repeat, it's not going to be the dissolution of the partnership firm. It is just that one relation which is going to change. And that's why we use the language dissolution of partnership. I hope you're understanding. Not the dissolution of the entire firm. It is just because that one partner has become insolvent, he's going to move out, and there will be a dissolution. There will be a breakage in our relation with that partner. So that is nothing but dissolution. Understood, everyone? Vijeta there in the session, understanding? Yes, next one. So one there. So this is on your insolvency. Will he be liable for anything which happens after his insolvency? Answer is no. He's not even associated. How can he be liable for it? Not possible. All right. Right. Outgoing partner to carry on competing business. Section 36. Can I carry on competing business when I'm leaving the firm? When I'm leaving the firm, can I carry on the competing business? Law says under section 36, I cannot carry on any competing business if at all restrictions have been imposed on while I was exiting. If no restrictions are there, can I also continue? 100% yes. If there are no restrictions, can I continue? Answer is yes. If there are restrictions at the time of my exit itself, if there are restrictions, should I respect that restriction? Answer is yes. I have no option at all. What are you talking, sir? Greek and Latin, we didn't understand. No problem. What are we talking about? Let's assume where Lakshmi, Pratiksha, Ashwini, Sumant, and me, all 5 of us are partners. All right. Now, I have decided I want to move out of the firm. Why? Because these guys are extremely active, so actively involved that I cannot be active anymore. So now I've decided that I want to move out of the firm. Now, while I'm moving out, Sumant says, sir, you move out. We don't care, but you cannot carry on the same business that we've been carrying out. What is he doing? He's stopping me from going ahead and carrying out competing business. Can he do so? Answer is yes. Will it be considered as a restraint on trade? Answer is no. This is not restraint on trade. But let's assume if he has not mentioned anything, can I carry on? 100% yes. Yes. Understood the concept, understood the point. Lasya, understood? Yes. Clear with whatever we've discussed? Yes. Shri Zaujanya, Diksha?
Yes, sir.
This is about your rights of outgoing partners. Sumant, understood? Ramakrishna? Yes, rights of outgoing partners in cases to share. I'm sorry. Anyone wants me to repeat?
Yes, sir.
I repeat. So what are we talking about? Sir, let's assume 5 of us are partners. I have decided to move out of the firm. Can they impose a restriction on me not to carry on the same business for some time or same place? Mute yourself, whoever it is. Can they impose such restriction by telling that you cannot do this business for 6 months in Bangalore or any such restriction? Answer is yes, they can restrict me. What would it be called? It would be called it would rather not be called a restraint on trade. Is it something that he is imposed? But is it void? No, it is valid. It is definitely valid. Now, let's assume if nothing is mentioned, will it be okay? Yes, in that case, I can go ahead and carry on any competing business. Since nothing is mentioned, I will carry on the competing business. As simple as that. Understood? Yes, Anju, clear with the concept? All right. Now, section 37 that we're talking about, right of the outgoing partner. Sir, I have left the firm, but still am I entitled to the profits after leaving? After leaving the firm, can I still be entitled to the profits of the firm? Answer is yes. Answer is yes. If my accounts have not been settled. All right. You were supposed to pay me. You didn't pay me. You have not even returned my capital, which was lying with you. Now, in that case, since you have my money, you are earning business out of it. You are making money out of it. Give me also a share in profit. Or listen to me very carefully. Very, very carefully. Either I get a share in profit or interest at a rate of 6% per annum, whichever is higher.
No, sir. Any one thing you have to choose.
Please note, whoever it was, you're right. Please note, law does not use the language whichever is higher. If in examination, by mistake, if you use this language, then it is wrong. Either it is the share in profit or 6% of the share. Interest at 6%. Full stop. Don't use the language whichever is higher, whichever is lower. That is something that you have created. Don't write it out. That if you write, trust me, it's a wrong answer. Who are you to decide whichever is higher? I don't want the higher amount. How can you decide? I want an instant money. I want regular money. I want 6% every year. Instead of seeing an irregular share in profit, if I can ask for a 6% per annum, don't you think that is better? How can you decide whichever is higher for me then? In that case, can you use the 6% whichever is higher? Law says no, I am not using it. Neither you will use it in your examination. I hope I'm clear, everyone. Understood the blunder that we could have done here? Yes, let's read the law now. Where any of the member has died or otherwise ceased to be a partner, and the surviving or continuing partners carry on the business of the firm with the property of the firm without any final settlement as between them, where accounts are not settled. That's what we are saying. All right. Without any final settlement of the accounts, the outgoing partner, in the absence of any contract, is entitled at his option. Look at the language. They are not saying whichever is higher. Rather, they are giving him the option. Whichever you want, you choose. What is the option? Shareth the profit or interest at the rate of 6% per annum on his share of the profit. Share in the property. Whichever is higher is not the language used here. Don't use it in an examination. Even after making this sentence, still people will use it. Then you'll end up costing yourself for 6 months. I hope I'm clear, everyone. Understood?
Yes, sir.
Understood, everyone? Yes.
Yes.
Next point. Registration of firm. Sir, is registration of the partnership firm mandatory? Answer is no.
No, sir.
If you want, you register. If you don't want, don't register. Sir, I don't want to register it today. When I'm incorporating, when I'm starting the firm, I don't want to register it today. I'll register after 1 year. Is it okay? Okay.
Yes, sir.
After
Okay.
10 years. Okay. Okay.
Yes, sir.
Why? Partnership is just an agreement
Agreement.
between two people. They decide what they want to do. How can law impose it? How can law impose that it has to be registered? Now, last year, the point is, if I don't register, what will happen? Simple.
Cannot
Nothing I found out. If you don't register, you cannot sue the firm or any of the partners. You cannot file a case against the third party. You cannot claim set off. I repeat, you cannot sue the firm or the partners. What is the meaning of this? Let's assume you've given 1 lakh rupee to the partnership firm. Partnership firm says, sorry, better luck next time. I don't have money. Can you file a case against the partnership firm? Answer is no. Why? Because your firm is not registered. Second case, let's assume you've sold goods to a third party. How much? 1 crore, small amount. Your pocket money. All right. One, don't compare it. One is the amount of goods that you've sold to a third party. Third party says, sir, sorry, I don't have money now. Come next year. Can you file a case against him? No, you can't. Why? Because you're an unregistered firm. Third, so let's assume I have to pay 10 lakh rupees to someone. That other person has to pay 6 lakh rupees to me. Can I set off and just pay 4 lakhs? Law says, no, you can't even set off. Why? Because you're an unregistered firm. These are the 3 problems if you don't register your partnership firm. No, sir, I want to set off. Okay, seeing your active faces, I'll give you the permission to set off. How much? 100 rupees.
100 rupees.
Up to 100 rupees, you adjust. Now you compare with your pocket money. I have no problem. I hope I'm clear, everyone. Understood? Understood? Crystal clear with the concept?
Yes,
Yes. So this is the whole discussion on your registration. Can a third party sue the firm which is not registered? 100%. Yes, he can go ahead and sue. Important topics which are often asked in examination. Difference between dissolution of a partnership firm, dissolution between partnership. All right. Before we go there, let's quickly read these 3 points as well. Can the third party sue the firm which is not registered? Third parties can
Yes, sir.
definitely go ahead and sue. All right. The rights of the partners to sue the dissolution of the firm or settlement of accounts of the firm for realization of the property of the dissolved firm is allowed. All right. What are the scenarios where the cases can be filed? Can a third party file a case against me? Yes.
Yes, sir.
Can I file a case against the partnership firm? I will
Yes,
give you
sir.
one. Yes. There is one thing which I will give you the permission to file a case. What, sir? Close the firm. I'll give you the permission to file a case. But for what? The permission is given so that you can file a case to close the firm itself. I hope I'm making sense, everyone. I hope I'm making sense. All right. So if you see indirectly, I haven't given you the right to file a case at all. I'm just giving you one right to close the chapter once for all forever. The third point, power of the official assignee. any receiver of the court to realize the amount, or in case if there is an insolvent partner, and the right to sue or claim a set off of suit does not exceed 100 rupees in value. So up to 100 rupees, you go set off. After that, if you want to set off, don't. You can't. Understood, Shresha? Yes. Can we proceed? Now, dissolution of firm and dissolution of the partnership. What is the difference? One of you quickly read all the 5 points. Quick.
May I?
Quick. Good. Anyone? All the 5 points.
Basis
Am I
of
audible?
defense. Yes, sir, you are audible.
Good.
Continuation of business, dissolution of firm. It involves discontinuation of business and partnership. Dissolution of partnership. It does not affect continuation of business. It involves only reconstitution of the firm. Winding up. Dissolution of firm. It involves winding up of the firm and requires realization of assets and settlement of liabilities. Dissolution of partnership. It involves only reconstitution and requires only revaluation of assets and liabilities of the firm. Order of court. Dissolution of firm. A firm may be dissolved by the order of the court. Dissolution of partnership. Dissolution of partnership is not ordered by the court. Scope. Dissolution of firm. It necessarily involves dissolution of partnership. Dissolution of partnership. It may or may not involve dissolution of firm. Final closure of books. Dissolution of firm. It involves final closure of books of the firm. Dissolution of partnership. It does not involve final closure of the firm of the books.
I hope everyone have got a fair idea of the entire thing. All right. Again, one of the most important topics, because they often ask this also for 4 marks. They ask this also for 4 marks in the examination. If you're lucky, imagine if you have this kind of questions, it's a straight short 4 marks for you. Straight short 4 marks for you in examination. I hope you're getting a fair idea of what we're talking about right now. All right. Can we continue? Consequences of dissolution. Sir, now you dissolve the firm itself, sir. You dissolve and close this chapter. Fair enough. So section 45 says, in case if you've decided to dissolve the firm, can the existing partners continue being liable? Answer is yes. They will continue being liable to the third parties until and unless you give the notice to them. If you don't give the notice of your dissolution, you will continue being liable to the third parties. Am I making sense, everyone? Yes. So let me quickly read an important phrase here. The partners continue to be liable as such to the third parties for any act done by them would have been done if done before dissolution until public notice is given of the dissolution. Very, very important, sir. If at all you have dissolved the firm, give a notice to the third parties, or else you will continue being liable to the third parties. Sir, how about death, sir? In case of death, how will the person give a notice? In dreams, nightmares? How? Law says, if the estate, provided that the estate of the partner who dies or who is adjudicated insolvent, or of a partner who, having been known to the third person dealing with the firm or to be a partner, retires from the firm, is not liable under this act even after the date on which he ceases to be a partner. What is the meaning of this? This is to say that in case if the partner is dead, if the partner is insolvent, or if the partner has retired, will he continue being liable? Answer is no. He will not continue being liable. But if it is a dissolution of the entire partnership firm, will the partners continue being liable? Answer is yes, because they should have given the notice to the world. They didn't. Now, in that case, they are going to be liable. I hope I'm clear. Everyone. Understood? Yes. Can we proceed? Now, rights of the partners to have the business wound up after dissolution. So, 6 says, sir, we have all given up our hopes. We don't think we'll be able to continue business anymore. In that case, can you file a case only for winding up? Answer is yes. So what will happen? They are going to ask the court to please go ahead and dispose all our assets. After that, if anything is available, after whatever you realize, pay all the liabilities. And after that, if anything is available, please give back the amount that we have contributed as capital. All right. So this is what your entire discussion under section 46 is. On dissolution of the firm, every partner or his representative is entitled, as against all the partners, to have the property of the firm applied to the debts of the firm and have the surplus distributed amongst the partners or their representatives according to their rights. So what is the meaning of this? So whatever assets are there, sell them. Whatever money you make out of it, go ahead and pay your liabilities. And after that, if anything is left, please go ahead and give the surplus to us. This is what your discussion is on dissolution and their rights. Understood, everyone? Yes. Next.
Yes.
Settlement of losses, one of the most important topics. All right. Losses, including deficiency of the capital, shall first be paid out of profits, next out of capital, and lastly by the partners individually in proportion to what shares they are holding. All right. So let's assume there are losses. How would you make good these losses? So use your capital. Before capital, let's assume we have our old profits. Use those profits and repay your liabilities. Repay your losses. All right. Whatever losses are there, make good those losses by using your liabilities, using your brought forward profits. Sir, we don't have profits at all. Use your capital. Sir, we don't have capital also now. Ask the partners to bring in the new money now. Understood? Ask the partners to now bring in the money. This is the mechanism which we are going to follow for the purpose of settlement of losses. Understood? Understood, everyone? Yes.
Yes,
Now
sir.
comes
Yes, sir.
payment of debts of the firm and of separate debts. Now, listen to me very carefully. Sumant and Anuya. Anuya, there in the session? Respond quick.
Yes, sir.
Anuya, there in the session?
Yes, sir.
All right. So let's assume Anuya and Sumant and myself. All right. All three of us, SAM, are partners in a firm, SAM and Co. Now listen to me very carefully. Sam and Co is a partnership firm. I have a property. I'm a partner. I have a personal property. I have my debts as well. I have my personal property. I have my debts as well. The same way, the partnership firm is also having debts to pay. My property will first be used for which debt? My debt or the firm's debt?
Personal debts.
Personal debt.
Losses. Sir, personal debt has to be repaid first. After that, if anything is left over, please give it to the firm. Case 2. I have a debt. The firm is also having a debt. Firm is also having its own assets. Can I use that asset to first repay my debts and then firm's debts?
No, sir.
No,
First,
sir.
Understood?
yeah.
Now again clearly says their property, the firm's property will first be used to repay the firm's debts. And after that, if anything is left over, it will be split and shared amongst all the partners, and you can take home the share of your property as well and repay your debts. Understanding, everyone? How
Yes,
do we
sir.
decide this and why is this important? Section 14. Property of the partnership. Partnership property. That's where we learned what is the property of the partnership and what is my property. If I wouldn't have been able to distinguish, imagine the problem here. Understood, everyone? The reason why we are speaking about it. Crystal clear? Yes. Next. Sale of goodwill after dissolution. All right. Section 55 says, in settling the accounts of the firm, the goodwill shall, subject to the contract between the partners, be included in the assets, and it may be sold separately or along with the other property of the firm as well. Why? What is goodwill? Goodwill is also the property of the partnership. Can I go ahead and sell it? Yes, go ahead and sell it. Let's assume I want to sell it to one of the partners itself. Can I do so? Dispose it that way. If you want to sell it outside, you can sell it outside as well. It is nothing but a part of the property of the firm. I hope I'm clear. All right. Can I sell it? Yes, you can sell it. Rights of the buyers and sellers of the goodwill. Now, to whomever you've sold it, can he impose restrictions? Look, I'm buying your goodwill, but you should not carry on the business in the same name, in the same area for some years. All of those restrictions can be imposed. 100% yes. Will it be considered as restraint of trade? Answer is no. This will not be restraint of trade. I hope I'm clear, everyone. Understood what we are talking about?
Yes,
Sleepy?
Yes, sir.
No, sir.
No, sir.
All right, brilliant. Let's read the law now. Where the goodwill of the firm is sold, all right, let's first read. Where the goodwill of the firm is sold after dissolution, a partner may carry on the competing business with that of the buyer, and he may advertise such businesses, but subject to the condition between him and the buyer. He may not use the firm name. He may not represent himself as carrying on the business of the firm. He may not solicit the customs of a person who were dealing with the firm before its dissolution. In simple terms, I can impose the restriction since I am the buyer. I will impose the restriction that you're not going to use this name. You're not going to solicit the customers. You're not going to ask the customers to come back to you. You're not going to do all of it. Is it possible? Yes, it is possible. Understood? Understood? Yes.
Yes.
The last says, any partner may, upon sale of goodwill of the firm, make an agreement with that of the buyer that such partner will not carry on similar business within the specified period or within the specified local limits, and notwithstanding anything contained in section 27 of the Indian Contract Act, such agreement will be valid and restrictions are imposed are reasonable, because this will not be considered as a restraint of trade. This in itself can be a question for 4 marks. Important phrase that you will have to remember is it is not going to be considered as a restraint of trade, and you have gone ahead and the other party, the buyer, can impose restrictions for a specified period, for a specified local authority, a local limit, or for a reasonable period that has been agreed upon. Understood, everyone? Understood, everyone? Yes.
Yes, sir.
With this, we end the second chapter also, which was pertaining to your entire discussion of partnership. All right. Now listen to me very carefully. Make a note of a couple of questions. Make a note of a couple of questions. Everyone, quick. Can we start? Can we
Yes,
start?
Yes, sir.
All right. So there's only one chapter left called LLP, which we are going to catch up in the next session. All right. We'll not do it in hurry. So let me know if you can see the screen as well. Is the screen visible?
no, sir.
No, sir.
All right. Just give me a
No,
second.
sir.
Just give me a second. All right. What we'll do is, rather, instead of dictating the question, since it will be as a part of your CAPS material already, let's quickly solve those RTP questions. It's there already in your CAPS material. We might have discussed also, just to ensure that you get a comprehensive idea. Is the screen visible?
Yes, sir, it is visible.
Yes, sir.
Right. We'll solve those RTP questions right away so that you get a complete coverage of the questions as well. One of you read the question. Quick. Am I audible?
November
Go ahead.
2020 RTP, question number 11. Master X was introduced to the benefits of the partnership of Miss ABC and Co. with the consent of all partners. After attaining majority, more than 6 months elapsed and he failed to give a public notice as to whether he elected to become or not to become a partner in the firm. Later on, Mr. L, a supplier of material to MS ABC and Co., filed a suit against MS ABC and Co. for recovery of the debt due. In the light of the Indian Partnership Act 1932, explain. First question, to what extent X will be liable if he failed to give public notice after attaining majority? Question number 2, can Mr. L recover his debt from X?
We've solved this question during our session. Nevertheless, this question is all pertaining to giving notice, not giving notice within 6 months. All right. So if you have not given notice, what will happen? If you have given notice, what would you be liable for? Am I clear, everyone? Let's read the law just to ensure that you have a comprehensive idea of the entire law as well. After attaining majority, within 6 months of his attaining majority, or on his obtaining knowledge that he had been admitted to the benefits of partnership, whichever is later, the minor partner has to decide whether he wants to continue remain in the firm or leave the firm. Where he has elected not to become a partner, he may give a public notice that he is elected not to become the partner and shall determine his position as regards the firm. If he fails to give such notice, he shall become liable in the expiry or in the firm on the expiry of the said 6 months. All right. The moment 6 months expire, he's going to be liable. I repeat the entire discussion. Listen to me very carefully. What does law says? Important terminologies, important phrases. First, is the screen visible?
Yes, sir.
Yes.
Sir.
Yes.
6 months.
Sir, it was-
First point, 6 months. Within 6 months, you have to decide what you want to do. All right. Or let's assume, sir, I didn't get to know immediately. I got to know later on. All right. Just because I've turned major does not mean that I will get to know. There's a high possibility that I got to know about it later on. Again, this also I'd given an example. Let's assume Temur. He wasn't even aware. After he attained majority, probably for 1 or 2 years, he didn't even get to know that he was a partner in your firm. He could not have become. He was admitted to the benefits of your partnership firm. He wasn't aware of it. All right. But after 2 years, he attained majority in 2020, and 2022, he got to know that he's a partner in your, he was a minor who was admitted to the benefits of your partnership. Now, what should he do? Law says, whichever date is earlier, the minor has to decide what he wants to do. All right. Once he has decided, decide within 6 months and inform what he wants to do. If he fails to inform the world, then he is going to be liable for everything that happens within an expiry of 6 months. Understood? Within expiry of 6 months, whatever is going to happen, he will be liable for it. Understood, everyone? Understood, everyone? Yes,
Yes,
no?
sir.
Anyone wants me to repeat?
Yes.
I repeat.
Here also it
Guys.
is minor being admitted to the benefits of partnership.
It has to be the minor admitted to the benefits of partnership itself. You cannot use the word minor partner. All right. Now, listen to me very carefully, everyone. What are we saying? So, two scenarios. All right. Two scenarios. I get to know on 18th birthday itself that I've turned major and I am a minor who was admitted to the benefits of partnership. Now, law says, I'll give you 6 months. All right. Within 6 months of you attaining majority, you decide what you want to do. There's a high possibility that I didn't even know that my father had admitted me as a minor to the benefits of the partnership. I wasn't aware of it. I got to know about it after when I turned 20 years. All right. After I turned 20 years, I got to know about it. Now, when will 6 months went long back. 6 months went past by long back. Now, what should I do in this case? Law says whichever is later date, you consider that and you decide what you want to do. If you don't want to continue, give a public notice and close it. If you don't give a public notice, immediately after your majority, I will assume that you had decided to continue and you will be liable for all the debts of the firm. Understood, everyone? Understood, everyone? Crystal clear? Diksha, yes?
Yes, sir.
Anyone wants me to repeat? I repeat.
Sir, from 18 to
I
20.
repeat. 200% focus. Pay attention to the details, everyone. Is the screen visible?
Yes, sir.
Yes, sir.
Yes, sir.
Listen to me very carefully. Sir, let's assume Lekha has attained majority. All right, Lekha there in the session has attained majority. Law says within 6 months of you attaining majority, and if you're aware, you already know that you're a partner in this partnership firm, you were admitted to the benefits of the partnership firm. I'll give you 6 months. Within 6 months, you decide. There are few cases in which I don't even get to know that I was a partner in this partnership firm. Let's assume Lekha got to know when she was 20. That time she got to know that she was admitted to the benefits of the partnership long back. So law says, sir, whichever is the later date, whenever is the later date, not the earliest date, not the earliest date, whichever is date, whenever you got to know, please go ahead and inform the public. Give a public notice telling that I don't want to continue anymore as a partner. Why? I wasn't even aware of it. The moment I got to know, I told them. If you forget to give notice, then I will consider you to be liable for all the debts that are attracted after 6 months of you attaining majority. After you attain majority, for 6 months, I have given you the cooling period. After that, you haven't given notice. The latest date also has passed by. Now, whatever debts are there after 6 months, you will continue being liable. Understood, everyone? Understood, everyone? Crystal clear?
Yes, sir. Yes, sir.
Now, this is the question on your minor. All right, let's go ahead. Question. Is it visible? Is the screen visible?
Yes, sir.
Yes, sir. Yes, sir.
All right. Let's see a couple of questions from your Companies Act as well. All right. Let me know if you can see screen. Quickly solving
Yes.
all the RTP questions as well. The latest RTP we will be solving in the next session. All right. This attempt's RTP will be solving in the next attempt. All the old RTPs I'm solving now. Quickly, one of you read the question.
May 2020 RTP, 23rd question. Examine the following whether they are correct or incorrect along with the reasons. Question A company being an artificial person cannot own property and cannot sue or be sued.
How will you answer this question if it is a 2-marker? How will you answer?
It is
Anyone raise your hands? No, don't blurt out your answer, please. Raise your hands and give me your answers. Raise your hands and give me answers. Good, Tejaswini.
So first we need to say that it is taken from the Companies Act of 2013. Give a small description about what is a company and then say as it is our artificial person, separate legal entity, it can own, it is incorrect statement, it can own property and can sue and can be sued by others.
First thing that you're going to do is please write whether it is correct or incorrect. Giving reference to the law is secondary. What is the question that they're asking? Examine whether the following are correct or incorrect along with reasons. You give the reasons after giving whether it is correct or incorrect. Are you guys understanding? So in this case, it is very clear it is incorrect. All right. So then now you give reasons. Why is it incorrect? Company is an artificial, agreed. But it can definitely own property in its own name and can sue or be sued. Based on this statement is incorrect. First, you tell whether it is correct or incorrect, and then you give your answers. Am I clear, everyone? Don't give reason before telling why it is incorrect. I hope I'm clear, everyone. Understanding? Yes? Let's go ahead with the next question. One of you read. One of you read quick.
November 20.
Am I audible?
Shall I say? Yes.
Please go ahead. Quick.
November 2018 RTP. Question number 1. ABC Private Limited is a private company having 5 members only. All the members of the company were going by car to Mumbai in relation to some business. An accident took place and all of them died. Answer with reasons under the Companies Act 2013 whether the existence of the company has also come to end.
Now, I know we have solved all of these earlier, but now the perspective is not about the answer. Now I'm teaching how to write an answer. I know that you know the answer, but that is not the objective. The objective is to teach how to write the answer. Am I making sense, everyone? Yes? Good.
Yes.
One of you raise your hand. Anyone, whoever wants to answer. I need some fresh hands. Because we've discussed all of this earlier also. Good, Manju.
Sir, company is going, sir. Men may come, men may go. That is not effective company, sir.
What is this, sir? Men may come, men may go.
Perpetual succession.
It is only example.
So you're going to talk about perpetual succession first then. All right. Next, sir. That's it. Next. That's it. What else will you write?
Corporate legal entity.
Corporate legal entity. Fair enough. Okay. What else will you write? Now answer. No, now no one will answer.
Private
answer.
company. Private company.
Private
So
company.
members are different from company itself.
Transmission of shares comes into picture.
Members are different from
Company itself.
owners is what you're saying. Okay.
Sir, we
All
will
right. Members are different from company.
Sir, we will apply.
I'm sorry, I can't hear you.
Sir, we
Good,
will
good,
apply
Amit.
the provisions of law in this case, sir.
What is the provision of law?
There is the perpetual succession, and we'll say that even if the 5 members have died, the company will continue. We'll give our
How will it continue?
by
How will it continue?
legal representatives can
So
take.
how will it go to the legal representative?
Transmission of shares.
That is the language. That is the language that I was waiting for. Transmission of shares. Transmission of shares. Transmission of shares. 99% of us forgot it. Am I making sense, everyone? There in the session? Everyone? Yes.
Yes, sir.
First, you talk about perpetual succession, like our friend rightly mentioned. Second, you talk about the number of members in a company required. Third, you talk about the transmission of shares, transferability and transmission of shares. Am I making sense, everyone? Yes. So this is how you're going to approach this particular question. I hope I'm clear, everyone. Understood? Yes?
Yes, sir.
Yes.
All right. Let's go ahead with the next question now. You've solved all of this, but that is just to ensure that you get a complete coverage. One of you read the question again.
May 2019 RTP, 11th question, first sub question. If an assessee was a wealthy man earning huge income by way of dividend and interest, he formed 3 private companies and agreed with each to hold a block of investment as an agent for them. The dividend and interest income received by the companies was handed back to F as a pretended loan. This way, F divided his income into 3 parts in a bid to reduce his tax liability. Decide for what purpose the 3 companies were established, whether the legal personality of all 3 companies may be disregarded.
Same question is there. May 2019 RTP, November 2018 attempt question paper, 3 marks. Can you see? Yes.
Yes, sir.
Same question, not even any tweak. A had large income, dividend and interest. In order to reduce, he formed 4 companies, transferred it to them. The income earned by the companies were taken back in the form of pretended loan. Same. F, wealthy man, income and interest given to the company. Here it was given in the form of pretended loan. This is into 3 parts, all of this. How would you answer this question? How would you answer this
First,
question?
first we have to write about corporate.
Guys, raise your hands and please answer. I don't want a fish market. Please go ahead. Now no one will raise. This is the problem. Go ahead, Samirana.
Sir, first we have to write about the corporate wealth theory, and we have to
Corporate.
write piercing the corporate wealth theory, and we have to write the to reduce income tax. After that, we have to write whether A is liable or not.
Scenarios, that is evasion of taxes. That is what you're going to write, right? Yes.
Yes, sir.
All
Yes,
right.
sir.
Anything else? And finally, you're going to give your conclusion. That's what you're saying?
Yes, sir. Yes, sir.
Now, please note, these are kind of case studies. How do you approach case studies? Listen to me very carefully. First, you write facts of the case. Facts of the case has to be only 2 sentences. Only 2 sentences. Understanding? Whatever our friend has mentioned, that comes as a part of my analysis. All right. Whatever our friend has mentioned, that comes as a part of provision of law, rather. Sorry. That comes as a part of my provision of law. All right. And then it comes as analysis where I'm applying the provision in the facts of the case. And finally, I give one liner called conclusion, which is going to be 1 sentence, only 1 sentence, which is going to cover the entire answer. Understood? Understood, everyone?
Yes, sir.
Now, next, let's see if there are any other questions as well on this. One of you read the question.
November 2018 RTP, second submission, define OPC, that is 1% company, and state the rules regarding its membership. Can it be converted into a non-profit company under Section 8 or a private company?
Straight question here, if you were to see. No case study. These are called direct questions. All right. What is OPC? Section 2 clause 62. Everyone will be able to write. Understanding? Yes. Next.
Sir.
You are going to talk about rules regarding its membership. Who can become a member? Indian citizen, natural person, whether resident or not. Resident is a person who is going to stay in India for a period of 120 days in the immediately preceding calendar year. Understood, everyone?
Financially.
Crystal clear, everyone? Yes, it is going to be financial year, not calendar year. Understanding? Yes. Then, whether it can be converted into a private company? Yes.
Yes,
Whether
sir.
it can be converted into a Section 8 company?
No, sir.
No. This is how you're going to approach this question. One of you read this question. Read the question, quick.
November 2019 attempt, question number B. Mr. Anil formed a 1-person company OPC on 16th April 2018 for manufacturing electric cars. The turnover of the OPC for the financial year ended 31st March 2019 was about rupees 2.25 crores. His friend Sunil wanted to invest in his OPC, so they decided to convert it voluntarily into a private limited company. Can Anil do so?
Forget about the marks. Don't get carried away with the marks. Why they've given 4 marks is because earlier the law was something different, which got amended now. And now it is very simple. Straight away, can you go ahead and convert it? Go ahead and convert. No one can stop you. As simple as that. Understood? Can I convert an OPC into a private limited company? Yes, I can.
Yes, sir.
I can. So this is what your answer is all about. All right. Same question. November 2019 question paper. November 2020 RTP. I hope I'm clear.
Sir, December 2022 attempt also it was came.
December 2022 attempt also it was there, is what one of our friends is mentioning. What are you going to do? Kindly go ahead, tell it can be converted. As simple as that. Understanding, everyone? Yes. Next point.
Yes.
One of you read this question. Quick. We've solved this question as well. Quick.
May
May
2019.
2019.
All right. So what I'll do, I'll read it. Sheer coincidence that both of you are not able to read. Listen, now, there's this public company, all right, which has 230 members. This company is planning to convert itself into a private company. I cannot have 230. I need 200 itself because that is Section 2 clause 68's requirement. Now, they have given the list of people who are to be included, who are not to be included. Directors and their relatives. Will I include? 100% yes. Employees will I include?
Consider them as
Answer is no.
no, sir.
No. Tell clearly that they are members by virtue of their employment. You will have to give this note or else your answer is wrong. Or else your answer is wrong. All right. Then ex-employees, again 10. Should I consider them? Answer is no.
No,
Give the same point again.
virtue of employment.
Presuming that they are holding or members by virtue of their employment. Next, 5 couples jointly holding in the name of husband and wife. How many will I consider? 5.
5.
Joint shareholders have to be considered as one individually. All right. So here there are 5 such ones. Will I consider 10 or 5? Answer is 5. Understanding everyone. This is another blunder. There might be people who might end up considering this as 1 because you only told no, sir, joint holders 1. What I'm saying is they are jointly holding. There are such 5 cases where jointly each one of them are holding two people are holding 1 share each. Like this, there are 5 cases. Should I consider them as 1? Answer is you will consider instead of 10, you consider them as 1, as 5. As 5. Am I making sense, everyone? Crystal clear? Yes.
Yes,
Now,
sir.
others, there are 5. Total 200. Should I reduce the number? Answer is no. It is well within the limit of section 2/68. I hope I'm clear, everyone. One of you read the question next. Quick.
Number
Quick, quick,
2003, examine the following whether they are correct or incorrect along with reasons. A company being an artificial person cannot own property and cannot sue or be sued. A private limited company must have a minimum of 2 members, while a public limited company must have at least 7 members.
True or false? First one, false. Second one, true. I hope I'm
True,
clear,
sir.
everyone. I hope I'm clear, everyone. Yes. Public company, 7. Private company, 2.
2.
Any other questions? Let's quickly see. Yes, there are 1, 2 questions. Let's quickly see this one. All right. What do you mean by a company which is registered under section 8? All right. Mention the conditions and issue and revocation of license. I hope each one of us will be in a position to write an answer to this. We've seen when it can be issued, who's going to issue it, what are the conditions for revocations as well. Then we went on to see what is the concept of dormant company. Dormant company, we've seen, understood each of these in detail. What is a significant account transaction? What is an inactive company and all of it. Then we went on to see if there are any other questions. Let's see. Briefly explain the doctrine of ultra vires. What are the consequences of ultra vires? I hope each one of us will be able to write an answer to this. Yes, no, there in the session.
Yes, sir.
Yes, because we've discussed this. All right. Next, this is on can Mr. X recover the money from Y depending on the relevant provisions of law. So AOA provides for the board of directors has authorities to issue this on doctrine of constructive notice and doctrine of indoor management. We'll have to check what exactly this is pertaining to, and you'll have to give your answer. What is covered here as well. All right. Next, clearly explain what is the doctrine of indoor management and explain the circumstances in which a person cannot claim a ground of doctrine of indoor management. That means an exception to doctrine of indoor management. Something again that we have discussed just some time back. All right. With this, we come to an end of today's session. We're going to catch up in the next session. We are going to wrap up LLP and we'll be solving one RDP. The latest RDP will be solved together. All right. We'll be seeing each of the questions and we'll have an analysis of how to approach the questions. All right. With this, I come to an end of my session. Thank you so much. And I hope you guys had a good time.
Thank you. Yes.
Thank you, sir.
Thank you, sir.
Very much,
Take
sir.
all the questions. Tejaswini, I'll take all the questions in the next session. All right.
Okay, sir. Thank you, sir.